morning, everybody. Happy Super Friday. Welcome to TCF Live. My name is Dan Sowell. I will be your guide through the next 4-hour journey through Courtlandia. But unfortunately, there's not a whole lot going on yet this morning. This is typical on a Friday, so we're going to start in the Wayback Machine. This is Judge Elmore from yesterday.
Judge, what we had discussed was dismissing counts 1, 2, 3, and 8. And he would plead to count 4, which is absconding from supervision. Count 5, 6, and 7 are violations of criminal law, and those correlate to criminal convictions that he had in North Carolina.
So
for
plead.
3 misdemeanor offenses.
So dismiss 1, 2, 3, and 8.
Yeah.
Plead to 4, 5, 6, and 7. All right.
Essentially, yeah.
All right. Good. Well, okay. Mr. Favre, is that what you want to do today?
Yes, Your Honor.
Please raise your right hand. The best that you can. Do you swear or affirm the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
Yes, Your Honor.
You may lower your hand. Mr. Favre, do you need me to go over what all these 8 counts are again?
Yes, sir.
No problem. I'll do it. I'll tell you which ones I anticipate are going to be dismissed and pled to. Count 1 alleges that contrary to condition 4.20, which requires that you must not use any weapon, it's alleged that on or about 11th of November 13th of 2016, you possessed and or used a weapon or imitation of a weapon. That count will be dismissed. Count 2 is an alleged violation of Rule 3 that requires you must not leave the state without permission, and more specifically that on or about August 11th of 2015, you left the state of Michigan. That one will be dismissed. Count 3 is a charge of violating condition 2.4 that requires that you must not use or possess any controlled substance or drug paraphernalia, and more specifically that on or about August 5th of 2020, you possessed cocaine. That one will be dismissed. Count 4 is an alleged violation of Rule 3, which requires you to make a truthful report to your probation officer as directed, and more specifically that on or about August 11th of 2015, you failed to report, and you were in an absconder status. That could have been initially a technical violation, but based upon it's more than 60 days, it's a non-technical. The difference between non-technicals and technicals, I'll explain in just a moment, but I'm told you're going to plead guilty to that one. Count 5 is an allegation that you violated Rule 1, which is not to violate any criminal law of any unit of government, and more specifically that on or about November 13th of 2016, you possessed a firearm as a felon. That one you would plead guilty to. That also is a non-technical. Count 6 is another alleged violation of Rule 1, which again requires you not to violate any criminal law of any unit of government, and again that on or about November 2016, you caused malicious damage to property belonging to a person named Marshawn Sharpe. Sharpe is S-H-A-R-P-E. That is also one to which you're going to plead guilty to, at least that's what I'm told. That is also a non-technical. Count 7 is another allegation of violating Rule 1, not to violate any criminal law of any unit of government, and more specifically that on or about November 13th of 2016, you committed an assault and or battery upon Marshawn Sharpe with a weapon. That one you'll be pleading guilty to, and that one will also be a non-technical violation. And lastly, count 8, which will be dismissed, is a violation again of Rule 1, not to violate any criminal law of any unit of government, and that on or about August 5th of 2020, you sold cocaine to another individual. Again, that one will be dismissed. If you enter a plea of guilty today, you'll not have a contested hearing. You'll be given up the right to have the prosecutor prove the allegations by a preponderance of the evidence, which is a lower standard of burden of proof than, say, proof beyond a reasonable doubt at a criminal trial. You'll be waiving the right to question and cross-examine any witnesses she presents. You'll be given up the right to present witnesses, evidence, or testimony in response to that. You'd also be given up the right to remain silent and not have that silence used against you. Also, based upon the original plea in this case, any appeal will be done by filing an application for leave to appeal and not a claim to appeal by right. You also will be given the right to claim that the pleas today were the result of any other promises, threats, inducements not told to me today on the record. Have there been any other promises, threats, inducements? All right. And has anybody made any promises to you as to exactly what the sentence would be from this court?
No, sir.
And have you had time to talk with Mr. Harrison about your rights and options and so forth?
Yes, sir.
And are you satisfied with his advice? He's been available to you and all that? All right, good, thank you. And again, because they are non-technical violations, the court's not limited to a sliding scale that only applies to technical violations. And therefore, the court's only limited by the amount allowed under the law. In this particular case, you were convicted of a charge of assault, resist, obstruct a police officer, which is a felony punishable by up to 2 years and or up to $2,000. It's a bit of a misnomer, even though there's a maximum punishment of up to 2 years. Michigan has a 2/3 rule. Means the most you could get would be 2/3 of those 2 years, but that would require a prison term. I'm told, while it's still up to me, that that side is not going to ask for prison. Okay. Do you still wish to enter the pleas today, as we talked about?
Yes, sir.
Do you have any questions of your counsel or of me before I take the pleas?
No, Your Honor.
As to counts 4, 5, 6, and 7, how do you plead?
Guilty.
Before the court can accept that plea, I'm going to ask you some questions. And before I do that, I'm going to take judicial notice of the terms and conditions that are contained here in the file that were signed by my predecessor, the Honorable Judge William Favre. And it looks like he signed them on or about November 16th of 2013, and then you acknowledged them on December 12th of 2013. So for count 4, back in August, on August 11th of 2015, is it true that you absconded from probation and stopped reporting? Okay. And as to count 5, is it true that on August 13th of 2016, as a felon, you possessed a firearm?
Yes, Your Honor.
And at that time, you were also on probation, so you couldn't possess one for that reason. And for count 6, is it also true that on or about that same date of November 13th of 2016, you damaged some property belonging to this individual named Marshawn Sharp?
Yes, Your Honor.
What kind of property was it that you damaged?
Vehicle, like a car.
And where were you when these things occurred?
North Carolina,
Okay. Where in North Carolina?
Morehead City.
Okay, well, that's okay. North Carolina is great, but Asheville would be better. Brevard, those are big mountain biking communities. Is it also true that for count 7, that on that same date of November 13th of 2016, you assaulted Marshawn Sharp with a weapon?
Yes, Your Honor.
Tell me about that. What did you do to commit an assault and or battery with a weapon?
He ended up threatening to jump me, so I just hit him with some a weapon.
And did he have any weapon at that time?
Not that I know of.
Okay, so therefore you might have had some self-defense issues, but you were meeting non-deadly force with deadly force. And what kind of weapon was it?
It's like a pole, like a little PVC pole.
Oh, okay, yeah,
But
all right. Ms. Dahl, do you believe you've provided factual basis to support the pleas for counts 4, 5, 6, and 7?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court's compliance with court rules?
Yes.
And Mr. Harrison, do you agree with all 3?
Yes, and you have.
Thank you. The court agrees and finds that the defendant's pleas today are made freely, knowingly, and voluntarily. The court further finds that the testimony provided by the defendant under oath on the record, in addition to the judicial notice taken of the terms and conditions of probation, satisfy the required elements of proof. Therefore, the defendant is found guilty of counts 4, 5, 6, and 7 as they appear on the amended request and warrant for probation violation dated March 31st of 2026. The other counts 1, 2, 3, and 8 are hereby dismissed. All right, can we proceed to sentencing now?
I'm prepared, Your Honor.
Ms. Dahl
Yes.
and Mr. Harrison,
I have no issue.
back to you, Mr. Van Amel.
Sentencing guideline range is 0 to 6. Continues to owe $825 in fines and costs. I last check, he had paid a total of $273 towards fines. He does have prior probation violations from 2014 and 15. Those consist of a positive PBT associated with a felon and curfew violation and not paying fines and costs. The violations in the warrant primarily involve behavior occurring in North Carolina that resulted in criminal convictions. He was convicted of assault with a deadly weapon, which is a misdemeanor, and injury to personal property. Due to all that, I would recommend 365 days jail with credit for 163 days served. Probation terminated as excessive, zero fine and costs.
All right. Thank you. Ms. Dahl, your position?
I concur with that recommendation, and I believe 365 days, the credit that he already has is appropriate.
All right, Mr. Harrison?
Ordinarily, Your Honor, I would do the same math here. Yeah, look at this. I'd note the prior violations. I would note that there's been some progress, but not a completion as far as the repayment of the monetary obligations. But there's one other thing to look at here. Well, two things really, and the dates are 2013 and 2016. 2013 was the date of this conviction. It's rather ancient history. And 2016 are the dates that have established the criminal convictions for which he is now guilty of violating his probation because of their commission. And even at that, those were 10 years ago. I realize one ought not to obtain a benefit by absconding. One ought not to be able to run away and simply due to the passage of time have all their misdeeds erased like so many footprints along the seashore. However, I also believe that his recent lack of contact with police agencies, anybody that would enforce this warrant, I think is pretty compelling. And I think it shows that he's had not only the actual physical time to grow up, but that psychologically, state of mind wise, he's also grown up quite a bit in the way he conducts himself in public. I would think all of that could be taken heavily into consideration here, especially with the 0 to 6 guidelines. He doesn't seek to walk away from this with no sanction, Your Honor. I just think under the circumstances that a year in county jail, despite his substantial credit, may be excessive. Thank you.
Thank you. Madam Clerk, I'm going to need new advisory rights, the ones that are in the file from 2009. All right, thank you. Mr. Favre, you have the right to make a statement before the court issues a sentence. Is there anything you wish to state, sir?
No, Your Honor.
Okay. All right. Well, looking at the the objections of sentencing, rehabilitation is one. I don't really know if that's what we're looking for here. This was a assault resist destructive police officer. Not much about, or really anything about what the facts were in this case back in 2013. But I look here at deterrence, and not only specific applying to Mr. Favre, but even more importantly, deterrence to the general public and to people who are put on probation, not to abscond. Had the defendant not absconded, things likely would have never happened. But he did abscond, and he's been gone for quite a long time. So, for me, that drives the reasonableness and proportionality sentence. The court preserves all fines and costs, terminates probation without improvement, and for a moment, so I do some math. Court sentences the defendant to an additional jail term. Court sentences him to 300 days with 163 days of credit. That means you should earn 50 days of credit. So in the end, you've got about 97 days or so. Did I miss anything, Mr. Van?
No, Your Honor.
Ms. Stoll? Mr. Harrison?
Nothing further, Your Honor. Thank you.
Thank you. Mr. Favre, Mr. Harrison's going to bring you from the clerk 2 copies of one document. You're going to initial one, acknowledging receipt of the other, and the other one you'll take with you. This document tells you that you have the right to appeal the conviction and sentence in your case today. But based upon that the original plea and sentencing, any appeal is done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the one copy that you're taking with you and return to the court within 42 days. Never dissuade anybody from filing an appeal. Keep in mind, it'll take more time just to even get the transcript done. But that's all up to you. All right. The copy that you place your initials on, you didn't elect nor waive your rights. You were just merely acknowledging for me that you got your copy.
Yes.
Any questions, Mr. Favre?
No, Your Honor.
All right, Mr. Favre, let's, one thing I didn't hear today is, lots of felonies and other stuff. So
I've been trying to better my life.
I know.
I know I made a lot of
It's-
wrong choices.
it's been about a decade since it looked like you got in trouble. So let's stay out of trouble. Thank you, folks.
Alrighty, friends, TCF Live. It's a super Friday. Good to have you all here. We can go live now and get out of the Wayback Machine. Let's go to Judge Anna Marie Anzalone.
Ms. Rowe, we are here for a warrant that was signed yesterday, which alleges that you have committed the technical probation violation and that you were placed on probation in order not to use or possess any controlled substances. You tested positive for cocaine on March 23rd of 2026. A confirmation was sent out and then received on April 1 of 2026. So, Ms. Rowe, you do have a right to have an attorney represent you here today or in any subsequent hearings. If you can't afford to hire one, we can appoint one at public expense. And I do have Ms. Underwood here in the event you would like court-appointed counsel. So, Ms. Rowe, would you like a court-appointed attorney?
Yes.
Now, Ms. Underwood, I am going to appoint you to represent her. I do want you to know this is not her first violation for testing positive for cocaine. She is a member of a recovery court. How many violations have we had for testing positive for cocaine or any illegal controlled substances, Ms. Tusky?
Twice, Your Honor, prior to this.
Okay, so, all right, I'm going to open up a breakout room and place you both in it to give you an opportunity to speak. And there we go. Mr. Mawad. Go ahead, Ms. Underwood.
Yeah,
I'm trying
sure.
that right. All right, so hold on one second. Mr. Shadler, or Mr. Lacoste, can you approach? I'm sorry.
That's okay.
I was thinking
So, I know,
that
I
right
know.
now.
I did call him and he said he's on now, so I went and I talked to Jefferson. And he said, continue it to the bench trial, and I did advise him if he fails to, but that they had to follow the interview and stuff.
Okay. So we're done.
Oh, we're done.
Okay. Thank you, Judge.
You're welcome. Okay. So, Mr. Mawad,
Yes.
good morning.
Good morning. Good morning.
Mr. Mawad, Miss Brian, she's not here either. Do you have contact with her?
Judge, if you can let me come back out, or do you want to just adjourn it? She's made every court appearance, so this is a shock to me that she's not. You want me to come back out and call her and see what we can do?
Yeah, if you want to try that, or I
You want
can
to
adjourn
adjourn
it.
it?
Whatever would work best for you, Mr. Mawad.
Why don't we adjourn it?
Right.
Let's
Miss
adjourn it. Let me
Adams?
find out what happened. She's been a good client.
Okay, Miss Adams, do I have anything available next week?
Yes, Judge, we could do Friday, April 17th at 8:15.
Mr. Mwada, are you available?
Oh, yeah. Thank you. I'll find out.
Mr. Mwada, you're breaking up really bad. So, why don't you, are you available next Friday at 8:15?
Yes, I am, Judge. Yes.
Okay, so we'll adjourn this to April 17 at 8:15 in the morning, and we'll send a notice out. Thank you, Mr. Mawad.
Okay. Thank you very much.
Thank you. Okay, so it is 9:04. So in the matter of FM Sylvan Inc. versus LaSalle Group, file number 24-247474 CB. Anybody? Nobody? Okay. Nobody's appeared for that settlement conference, which means probably settled, and they just didn't tell us. All right, Ms. Underwood, let me bring your client back. Jail.
Judge, can I ask a question? What is the
Hold on.
status? It's not about this case.
Oh, okay.
It's just in general, what is a status conference? Like, I got a status conference on a notice on a guy that I had wrote a PSI on in the past, and I don't know what I should be doing with it.
I don't know. So
Okay.
why don't we wait?
I'll bring it
before-
over and ask.
Yeah, and then we can look up the court notes to find out why.
Okay.
Okay, so we are back on the row, or on the record with Miss Rowe. Miss Underwood, have you had an opportunity to have a discussion with Miss Rowe?
I have, Your Honor.
All right, and how do you wish to proceed today with Miss Rowe?
Ms. Rowe, I wish to enter a not guilty plea on Ms. Rowe's behalf. Your Honor, she went and swabbed at CPS immediately after Sarah told her she was dirty, and that came up clean. So we have some real questions.
So, Ms. Underwood, what I will advise you is that the tests that CPS use are not the same tests that we use. So their levels are much lower. So I don't care if she tested Ms. Rowe, I'm talking. I don't care if she tested at 3 other places. Our tests are the only ones that matter. And
But
so,
I know they aren't always real accurate, Your Honor. And I know
they're less accurate.
Mr. Post swabs are the gold standard. So what I would ask, Your Honor, is that Ms. Rowe is working. I would ask that she be given a PR bond, this separate hearing, and she tests daily with swabs from Mr. Post.
Okay, so. All right, so I'm going to enter a plea of not guilty. Miss Adams, could I have the book, please?
Yeah.
Who would you have as witnesses, Miss Underwood?
I want to look at the results, and I want to see who will have.
Okay, you do
I may have-
understand that this
I
test
may
was
have
sent off.
CPS, I may have,
Miss Underwood, you do understand that this test was sent off to a lab. It's not just the test that was done at the courthouse. This test was sent to a lab. Miss Rowe, put your hand down. And so that would be the gold standard for the lab test. All right. And this is her 3rd violation. So I don't know that I'm going to consider a PR bond at this point.
It's not.
So, how much time do you need to get those people available, Miss Underwood?
not long, Your Honor. It doesn't sound like the court's never mind.
I can set this for 11 o'clock on Wednesday, April 15. That would be next Wednesday. Obviously, I don't want to delay it more than what you need to accommodate your witnesses.
Well, Ms. Rowe, do you want to have another breakout?
You know,
Yes,
Ms. Underwood, can I put you in a breakout room with Ms. Teskey? Perhaps Ms. Teskey could give you a little bit more information.
No, I want another breakout.
Okay, I will give you another breakout room with Ms. Underwood, but Ms. Underwood, would you like a breakout room? Ms. Rowe, hold on a minute.
I was.
Oh, you're gonna give me a chance to talk.
All right, so first of all, your attorney advised you were entering a plea of not guilty, which means I'm not gonna let you say anything that could be used against you. I was asking first if Ms. Teskey and Ms. Underwood would like a breakout room, because that way Ms. Underwood has a clearer understanding of the background and the determination of the recovery court and the discussion. So that way your attorney is fully knowledgeable about some of the allegations in this. So, and then I will give Ms. Underwood a breakout room with you, of course. But Ms. Underwood, would you like an opportunity to speak with Ms. Teskey? All right, so Ms. Rowe, I'm going to put Ms. Underwood and Ms. Teskey into a breakout room. Hold on. And then when they come back, I will put you guys into a breakout room. All right, anybody here for MPI debt fund? Okay, all right, so this is in the matter of NPI debt fund file. This is in the matter of NPI debt fund 2 LP versus Addison Development Phase 1 LLC, Suburban Propane LP, Michael W. Botsky, David C. Urton, Beauregard Harvey, and Daniel B. Peterson, and Daniel B. Peterson and David C. Urton as defendants, counter complainants, cross plaintiffs versus Addison Development Phase 1 LLC, file number 23-7032CH. Now I have hiccups. So do I have Stephen Jacobs present?
Yes, good morning.
Okay, P68749. Mr. Harvey is present, and Mr. Harvey, I do understand you're an attorney in another state, just not Michigan. And then John Lovinger, P41585. And then I have Craig Eoff out of Ohio, 71002, Prohoc Vici, and they are attorneys for the defendants, counter plaintiffs, cross plaintiffs, and Mr. Lovinger is counsel for Mr. Botsky. So, and Mr. Jacobs for the plaintiff. So we are here today on a final settlement conference. Again, so we've adjourned that, I think, a little bit. So, did the parties engage in facilitation? Mr. Jacobs, I'll just start with you.
Certainly, Your Honor. The parties did not do, they never did formal facilitation. There was a period of time when we did have it scheduled, but then a bankruptcy had been filed.
Okay.
That kind of derailed it. We were going to use, I had used them before in another matter in your court. Phil, I think it's
Bill Godfrey? No.
No, it's oh my gosh, I can't think of his name right now. Schaefer.
Philip Shadler, and he recently passed away.
He did? I didn't know that. Oh my gosh. Yeah, so we were going to use Mr. Shadler, but so unfortunately, no, we hadn't. During this time period, we have attempted to hold informal settlement communications between the parties. Unfortunately, we haven't been able to come to any type of resolution. We thought we maybe had some different avenues, but unfortunately, nothing's really come to fruition.
Okay. So at this point, obviously, I don't want to get into what any of those negotiations were. Do the parties want an opportunity to facilitate on your client's behalf?
I would not be opposed to still attempting facilitation, Your Honor.
All right, Mr. Lovinger and Mr. Eoff.
I have no objection to that.
I certainly have no
I need
objection
you
to that.
folks to speak up, please.
Okay, so, Mr. Lovinger, could you state that louder?
Yeah, I have no objection.
And Mr. Eoff?
Yeah, I have no objections to that.
Okay, and Mr. Harvey?
Judge, I have no objection either to facilitation. I do think I need to amend pleadings, but I have no objection.
Okay. Okay, so this is a 23 file. This is an older file, obviously. So I don't want to delay too long, but any objection, Mr. Jacobs, to any amendment of pleadings as stated by Mr. Harvey?
You know, Your Honor, I would like to be able to see what the proposed pleadings would be. I know I'm not trying to make more work for everybody, but this is an older case, and based upon some of my communications with Mr. Harvey, I do have some concerns that maybe some of the claims wouldn't maybe be appropriate in this action. So I would prefer to be able to see that actual proposed any proposed pleading before agreeing to something of that nature.
All right, Mr. Jacobs, would you like to weigh in?
Your Honor,
I'm sorry, Mr. Lovinger.
Yeah, I would agree with that. There's been a lot of representations made verbally that haven't been followed up. Right from the get-go, there were representations that there was going to be a very strong defense raised by asset development. Hasn't happened. Similarly, Mr. B, he's coming in, he's going to come in guns a-blazing, no appearance even. And one of the things he likes to talk to us about is that he hasn't been served. Well, he's here today. So I think he's aware of what's going on.
Okay. And Mr. Yeah.
Thank you, Your Honor. I mean, my view on it is that much similar to Mr. Jacobs, I don't know that any of those amended pleadings would have claims against my people. I don't know, but obviously I would like the opportunity to see them. And if I think they need to be attacked, I would attack them appropriately under Michigan law.
Yeah, and obviously we get pleadings all the time, striking. All right, so, all right, so it looks like for the most part, everybody's filed. All right, so I will allow Mr. Harvey to amend his pleadings, but obviously all counsel have the right to object to any of the amendments. I'm going to order facilitation. Again, it was a loss for our community when Mr. Shadler passed away. I do not choose facilitators, so anyone that you use for facilitation would be at your own choosing. And let's say facilitation must occur by July 31. And that would give you probably to June 1 to amend your pleadings. Well, no, it's
fine.
April, May, June 1.
Thank you, Judge.
Okay, and then I'm gonna set, is there anything else you want other than a settlement conference at that point?
Well, we could do settlement conference. Is it too far out to be able to have the court schedule a trial date so we have it on the books, or? I know your docket's very busy, Your Honor.
Right, but usually civil trials I can schedule within 3 to 4 months from the settlement conference.
Okay.
But I can, it would be, I mean, I'm fine with that. I'm looking at, how many days do you think you need for trial?
I think it would be no more than 2 days as it sits right now.
Does that include jury deliberations or no?
This is a non-jury trial.
Oh. So then we need a settlement conference in front of Judge Olsaver. So we call Judge Olsaver's office.
Hello, you have reached Judge.
Hello? Hey, is Frances over there by any chance?
She is over here.
Can you tell her I need a settlement conference date from her?
Okay, no problem. I will let her know.
Okay, bye.
Bye.
Just a minute.
Well, friends, as compelling as it is to have one court call another court, let's go ahead and move on. Good morning once again, everybody. TCF Live. Good to have you here. Let's go here. We haven't been here since the last time we were here, and that's a fact. Miami-Dade, Mindy Glazer.
Good morning, Mr. Bennett. You have an arrest warrant from Broward County. The warrant was issued March 25th of 2026. You missed court for tampering with a witness and battery. I will appoint the public defender's office for you. Unfortunately, there's no bonds. You will have to wait up to 15 days for Broward County to come pick you up. The reset date here is April 27th to make sure you are transported there. They usually come once a week, so hopefully you'll go pretty quickly. Have a nice day.
Okay, thank you.
Thank you, sir. Next is Samuel Joseph. He's at Metro West 2. Good morning, sir. You have an arrest warrant from Broward County. The warrant was issued May 16th of 2024. You missed court for robbery with a weapon in violation of probation. I will appoint the public defender's office for you on this arrest warrant. There's no bond. You're going to have to wait up to 15 days for Broward County to pick you up. The reset date here is April 27th to make sure you are transported there. Have a good day. All right, next, we have Kevin Volsey. Good morning, sir. You have a warrant from Broward that was issued February 12th of 2026. It says misdemeanor capias for driving with a suspended license. I will appoint the public defender's office for you on this warrant. Your bond is $2,000. If you're able to post a $2,000 bond, please do so here in Miami to get out of jail the quickest way. If you're unable to post a $2,000 bond, you will have to wait up to 15 days for Broward County to come pick you up. The reset date here is April 27th to make sure you bonded out or transported. Have a nice day.
All right.
Thank you, sir. Next we have is Idel Cardoso.
Good morning,
He's
Your
over
Honor.
Metro West 3. Good morning, sir. Is English okay for you?
Yes, ma'am.
Thank you, sir. You have an arrest warrant from Palm Beach County, Florida. The warrant was issued April 7th of 2025 for violation of probation. I will appoint the public defender's office to represent you on this warrant. Unfortunately, there is no bond. You will have to wait up to 15 days to be picked up by Palm Beach County. The reset date is April 27th, and I believe they come once a week, so you shouldn't have to wait that long. Have a good day.
Thank you, ma'am.
Thank you, sir. Next is Frederick Day. Good morning, sir. He's at Metro West 4. You have an arrest warrant. It is from Sarasota County, Florida. The warrant was issued December 31st of 1987. That's quite some time ago. Anyway, it's for violation of probation. Sir, can you afford to hire a private lawyer on the warrant?
I will be able to, yes.
All right, so they gave you a bond. It's $20,000. If you want to post that $20,000 bond, you can do so here in Miami. You'll get out of jail. You just want to make sure to keep all future court dates in Sarasota County, because if you miss court again, a warrant will be issued. All
Yes,
right,
you're in
Steve?
there?
Your Honor,
Yes, 1 second, corrections?
each warrant has, the first warrant says 2 counts aggravated battery, bond 10,000.
Oh,
The
it's
other-
10,000 each count. There's 2
Right,
counts.
but there's 2 counts in each warrant, so it's a total of 4 counts.
There
So we
can't
don't
be
have
4
a breakdown.
But they said total bond is 20,000.
So it's 5,000 each?
$5,000 bond each count, total bond $20,000.
Okay.
All right,
So
so, yes,
I already posted the 20,000 bond.
they probably made you come here to see me first. They sometimes do that.
They said because there was a discrepancy of it should be 40 or 20. So if I already,
Corrections, it's 20,000, 5,000 each count. Do you need an order or no?
I think you should do an order. I believe he was trying to bond out and the county was not accepting the bond.
right, because I already did, and I've been sitting here for 3
Yeah,
days
he was trying to
waiting.
bond out, but he does have first appearance on his jail card, so maybe after this.
So what do I do is my question.
So what do you need an order that says? 5,000 each count?
Yes. It's 2 warrants inside the fugitive warrant. You need the warrant ID number, the warrant numbers?
I see it here. It says
Okay.
1 warrant number for case number.
If I may chime in, there should only be 2. There shouldn't be 4.
Corrections, I see case number for 1, and then another case number. I don't
For
understand
two.
the case numbers, how they're written.
Yeah, they're different case numbers.
So how do you want me to do the order?
So warrant 1 is the 1986
Yeah.
CF
Yeah,
000736 NC, and then the warrant number 2 is 86.
yeah, I got it.
It
See,
sounds to me like it's the same, because
It
it's
is.
736.
Yeah, I mean, I know they're the same. I'm just trying to help
So
you.
I think we need clarification on this. I don't know if they want to call the county.
They've tried to call them and Sarasota's not returning. I mean, I posted the 20,000 already. I mean, I'm just trying to figure out. I mean, I posted it on Tuesday.
2 counts of aggravated battery and 2 is violation of probation for aggravated battery. So what do you want it to say? Counts 1 and 2, 5,000 each count, total bond 10,000 for the first warrant?
Yes.
All right, I'll try and do an order. Hopefully it works.
So is it the same warrants or no? Because it seems to me like it's the same numbers.
Because it's a violation of probation, yeah.
I don't know if the PD wants to contact the county.
He can afford a private lawyer.
Oh, okay.
Yeah, I mean, I need to get out to do that.
I'll just write something up and hopefully it works. As long as the jail here accepts it, he gets out, right?
Should be, yes. So it's gonna be a total of 20,000?
Yeah,
5,000 each?
How much? 5,000?
5,000 each?
Yeah, 5,000 each count.
Okay.
Okay, so if my bond is already posted, do I have to do anything else? Do I have to do it
I
again?
don't think they're gonna accept it until I do an order, and I can't do that till at lunchtime, so you're gonna have to sit tight.
Okay, no, I mean, do I have to go through the whole posting
No,
again?
call your bondsman, tell your bondsman to look at the back of the jail card. We're gonna look for the paper order at the back of the jail card for the clarification. Sir, are
Okay.
you residing at the Monmouth Avenue address in New Jersey?
Correct.
Is that a house or apartment?
It's a house.
That's just so they can give you future court dates, okay?
Yeah.
Okay.
So I should be out of here today then? Is that safe to say?
I hope so. We'll see. I'll follow up on it and make sure there's no issues, okay?
Thank you, Your Honor. I appreciate it.
All right, good luck to you, sir.
Thank you.
Next, we have Abelardo, and the reset date is April 27th. Abelardo Ramirez Barbier, he's over at Metro West 5. Good morning, sir.
Good morning.
You have a warrant. It says hold for immigration, and Spanish, please.
Tiene una orden de arresto y una retención de inmigración.
It looks like he has a hold from Volusia County. Is it a let me see something.
Parece que tiene una retención.
It may be a violation of probation. I will appoint the public defender's office for you on this hold.
He also has immigration.
Parece que tiene una retención del condado de Collision y voy a nombrar al abogado de oficio para que lo represente. Tiene una vulneración de probatorio.
I don't have any information what it's for, just says hold.
No tengo ninguna información de por qué es la
He came-
retención,
is he
simplemente dice
just a-
retención.
Judge, I have driving while license canceled or suspended or revoked.
That's
Yo
from
lo que
the
tengo
district.
es que tiene una conducción con la licencia suspendida o revocada.
That's from Volusia County.
Sí,
Do you
y
know if he's
esto
on
es del condado
probation?
de Volusia.
Mr. Wilson, you want to look into this?
Sorry, Your Honor.
For Mr. Ramirez Barbier, it looks like he came in on a hold from Volusia County. He was previously at the Broward Sheriff's Office jail, but they're not holding him. It's Volusia County. So is this one
Pero
where
están
he's on
intentando
loan?
dilucidar la retención que tiene del condado de Alusha.
Corrections, was he on loan?
Judge, I'm showing no bond on the jail card.
En la tarjeta del arresto de la cárcel figura que no tiene fianza.
Do you know if he's on loan? Or is it a
Excuse me,
hold for
Your-
violation of probation?
La juez pregunta si es una retención por una vulneración de probatorio.
No.
No.
I don't have any information, corrections on here, what this is about, other than hold.
On the jail card, I have
No tengo
hold for
información.
Volusia County. But driving while license suspended, no bond. That's what I have on the jail card.
Thank you.
Lo que tengo en la tarjeta de la cárcel es que tiene una retención del condado de Alusha por conducir con la licencia suspendida.
All right, let's set it April 15th to see if a warrant's been issued.
Vamos entonces a reagendarlo para el 15 de abril a ver si se ha emitido
Actually,
una
the
orden.
16th, April 16th, to see if a
El
warrant's
16
been
de
issued.
abril a ver si se ha emitido una orden de arresto.
Okay?
He also have the ISO, Judge.
Yes, he has an immigration hold. I've said that now 3 times.
Tiene una retención de inmigración, ya lo he dicho 3 veces.
Thank you.
Gracias.
Your Honor, someone just called from warrants from
Yeah.
MDPD on Frederick Day. Apparently, they're waiting for a teletype from Sarasota County. So it's supposed to only be 1 warrant. So it should only be 1, should only be 10,000. But we're waiting for them for a teletype.
Okay, so
Excuse
one
me, can
So I
warrant.
don't know if you want to hold off on the order, yeah.
Should I do the order that just says 10,000, one bond? I'm at this point, I'm so frustrated. I'm ready to release them, but I'm not gonna do that.
I know.
Parece que hay una orden que dice 10,000.
This
10,000
is, he
dólares.
doesn't
La
need the
juez-
interpreter for this. It's not him, it's the other person. We're done with this person.
Okay, sorry.
It's
Sorry,
reset
Your Honor.
April 16th. Can you let Mr. Day know it's 1 warrant, 10,000?
Okay. So you want to change the 5,000 each, 10,000 total,
Yeah,
order to follow?
what do you want me to do? A 10,000 each?
No, it should be 5,000 each. So it's a total of 10,000.
So on the 1 warrant, it'll be for the regular case, underlying case, 5,000, and the other little case number, 5,000. Total bond, 10,000. Does
Okay,
that work?
that's fine.
What's another way you want me to write it out?
I don't know because I don't know what they're gonna, we're waiting for the teletype.
All right,
So-
maybe you'll get it before.
Yeah,
it's over.
If not, we'll put it on the afternoon.
Okay. Now we have Hansani Weaver.
Good morning, Judge.
You have an arrest warrant from Brevard County, Florida. The warrant was issued on April 8th of 2026. The charge is failure to appear for sounding docket for driving with a suspended license, $2,000 bond. Also failing to appear for resisting an officer without violence, $1,000 bond. I will appoint the public defender's office for you. Your Your total bond is $3,000. If you are able to post a $3,000 bond, you can get out of jail. If you don't have any money to post the bond, you will have to wait up to 15 days to be transported to Brevard County. The reset date here is April 27th. Have a good day. Okay, thank you. We're done. Regular calendar. Correction,
morning.
creditor, Malik.
Corey, Assistant Public
Good
Defender.
morning. Malik Aquamina, page 10. Out on bond, hold for F-25, 19315. Good morning, sir. You were arrested for carrying a concealed firearm. I will appoint the public defender's office for you. So he's underage to carry a concealed firearm. There's probable cause. He has a hold since he's out on felony bond. And you'll see your judge Monday. The bond will be $2,500. Have a good day. Next is Evans Ellison, page 11.
Mr. Ellison has a writ of body attachment with the cash purge of $2,500.
Thank you. Good morning, sir. You were arrested for 2 cases. Battery on a law enforcement officer and resisting without violence, and another case for driving with a suspended license, third or subsequent conviction. I will appoint the public defender's office for you. There's probable cause for driving with a suspended license, third or subsequent conviction. That bond will be, how long have you lived here in Miami?
Since 1977.
All right, I'll set the bond on this case at $1,000. No driving unless you have a valid license, okay? The other case I gotta review. And then the other one. There's probable cause for battery on a law enforcement officer and resisting an officer with violence. Count 1 will be $4,000. Count 2 is $1,000. Have a good day. Anthony Wright is next, page 13.
Mr. Wright has 2 traffic judge. He'll go over to Jenna next.
Thank you. Good morning, sir. You were arrested for leaving the scene of a crash, no serious injury. I will appoint the public defender's office for you.
Judge, it should just be a misdemeanor. There are no injuries alleged.
Let's reset it for probable cause hearing in the afternoon. Mr. Brookfield, could you call any officer or trooper? I'm not sure if it's a trooper. No,
Will do,
it's-
Judge.
Can you call any officer, please?
Will do.
Thank you. Reset it for probable cause hearing. We'll see you later, sir. Next is Jesse Shaw.
Judge, is he allowed to bond out?
He's
Mr.
allowed to
Wright?
bond out, yes. Good morning, Mr. Shaw. You were arrested for 2 cases, retail theft with a prior conviction from April 8th.
Judge, Mr. Shaw refused.
Oh, Shaw refused, excuse me. Let me review for probable cause. So there's probable cause for petty theft 2 or more convictions on F-26 6993. And F-26 6991. There's probable cause for, well, based on the other case, there's probable cause for petty theft 2 or more convictions. Oh, both cases mentioned it. Reset for the afternoon. Next case is Luis Flores. Is he here?
He refused, Judge. We can waive his presence, Judge. It's an added charge.
Looks like it's a charge of,
First degree misdemeanor.
petty theft. Let me see the other case. So on F 267031, there's probable cause for petty theft. Appoint the public defenders. You said you're waiving, right?
Yes.
Appoint the public defender's office, waive presence. On this case ending in 7031, it's a $500 bond. The other case, there's probable cause for retail theft. The bond is $2,500. F 267030, $2,500. Next is Oscar Sawyer.
Mr. Sawyer refused, Judge, this is it.
He refused?
Yes.
And he's a sentenced inmate?
Yes.
Judge, we'll waive his presence. Christian, do you know when the sentence expires?
It expires on February 1st, 2027.
Thank you.
I apologize. Which defendant is this?
This is Sawyer?
Oscar Sawyer. I only see probable cause for petty theft.
Correct.
You want, bond is $500, appoint public defender's office, waive presence. Next is Mr. Armani Brown. Good morning, sir.
Added charge.
It's an added charge. You're arrested for the case from February 11th of 2026, burglary to an occupied dwelling while wearing a mask and attempted burglary to an unoccupied conveyance. I will appoint the public defender's office for you. All right, so state you filed a motion on this because of count one.
Yes, Judge.
Your order to stay away from the alleged victims, the alleged victim, Alberto Trejo, no contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. Stay at least 500 feet away from the victim, his home, school, and place of employment at all times. I'll find probable cause for burglary to the occupied dwelling and attempted burglary to the unoccupied conveyance. As to count one, the burglary to the occupied dwelling while wearing a mask, that will be no bond. Count two is $2,500. And I'm granting the state's motion for pretrial detention pending final hearing. As to count one, you'll see a judge on Monday. Have a nice day. Lower the earth.
Barbara, thank you for the $5. Treats for Ellie. Ellie appreciates you very much. Thank you.
Next is Marshawn West.
Added charge.
Thank you.
Judge, he's a private attorney on this other case, Mr. Iamuno.
Good morning, Mr. West. Thank you. You were arrested for one count of second-degree murder, one count of possession of a firearm, weapon, or ammunition by a convicted felon. This is a case from October 27th of 2019. Sir, are you going to be a private lawyer on this case?
Yes.
Okay, so we have to reach out to Mr. Iamuno and see if he's coming into court. Give me a second. I don't have the phone. So, I don't know his number. Do you want me to just set it in the afternoon? Is he at a facility?
Yes.
Facility judge.
He's from Metro West.
Do you have a victim's phone number? I mean, the victim's phone number we can call over?
Not with you? Not worth it, Judge. I can look it up.
If you look it up, tell me that. Renee to call over. So this is October 27th of 2019. The victim was riding his bicycle, stopped in the road to talk to other people. He had a dispute with Mr. West, and it says that he shot him. And then it left. And the victim left. And then you're the victim's felon. So technically, there's probable cause. I'll make a preliminary finding of probable cause. Yes.
The cell phone for Mr. Iamuno, 786-853-6297.
Okay, let's give him a call. And I'll pass this case, so just sit tight for a minute.
Thanks.
Would you go ahead? Next, we have Michael Malcolm, page 16.
He refused.
Let me review for probable cause.
Correction, what's Mr. Malcolm's bond on the traffic bench warrant? $1.
So there's probable cause for the charge. Let's set it up. What do we prejudice? Set it in the afternoon.
We'll waive his presence, Judge. Would you consider that he has a $1 bond on the traffic and lower his bond, Judge, so he can try to get out?
$1,000 bond. When public defender's office, waive presence, $1,000. Next, on page 17, Butler.
He's in Ward D. I'm promoting now. They're joining.
Good morning, Mr. Butler. You were arrested for possession of a firearm by a delinquent. I will appoint the public defender's office for you. There is probable cause for the charge. He shot himself with a gun that he wasn't to have because he's a delinquent. I'll set a bond $5,000.
Mr. Butler, can you afford a bond?
Well, he had money to have a gun, so maybe he has money for a lawyer. I'm sorry, for a bond, excuse me.
Mr. Butler?
Yes, I can afford a bond.
Yes, okay. Do you have a phone number of somebody we can contact to post your bond?
Probably one of my aunts.
Your aunt? Do you have a phone
Yeah.
number for your aunt?
Yeah, 786.
$8002.
Yeah.
Okay, I'm gonna reach out to your aunt. When you get out, if you can contact the public defender's office, you have to stay out of trouble and come back to court. Okay?
Yes, ma'am.
And corrections, if you can give Mr. Butler the phone number for the public defender's office?
Okay.
Thank you so much.
Mr. Glickfield, do you care if I lower the bond to like 3,500?
No, Judge.
That way we can get out of jail quicker. Okay. hopefully easily. $3,500. You're getting a little break today. Don't play with guns. You're obviously not very good at playing with them, and you should have them until you're 23 because you're adjudicated delinquent. All right. You can
Yes,
get
ma'am.
your turn. Have a nice day.
Okay.
Next case. Families in court for somebody. Let me call up Daquan Fountain on page 12. You can come on, that microphone works.
Is that for private attorney?
No, for families in court, for
Okay.
Daquan Fountain, page 12.
He's coming in.
Good morning, sir. You were arrested for grand theft. I don't know, it talks about a riot. There's no riot. It should be grand theft, a third-degree felony. So I guess property was taken from FedEx, $2,000, 11 items of fragrances. I will appoint the public defender's office for you. So he was seen going through CCTV footage, going through property and taking the cologne from the boxes. There's probable cause for grand theft. Sir, you are ordered to stay away from the FedEx location at 10400 Northwest 122nd Street in Medley, Florida. You are not allowed to go to that location. You must stay away from there. Do you understand, sir?
Yes, ma'am.
All right, pretrial. Okay, pretrial services, alternate bond, $2,500. Have a good day. And your family's here in court. Who are you all? I gave them, you can get out of jail for free with pretrial or post the bond, whatever makes you happy.
Okay, thank you.
Thank you. Thank you. Have a good day.
All right, as Michael pointed out in the chat, her audio is like 5% better than what we had the last time we went there, so they probably did like a $20,000 upgrade or some other, government craziness. Let's head up to Michigan. We'll say good morning to Judge Simpson, who's getting his day going.
Your name?
Staring at it.
Excuse me one moment. What are you doing?
Wrapping up my cord, Your Honor.
Oh, okay, all right. You just say you're pulling wires out of the table. I was worried. All right. I have before me a plea form. Form indicates that defendant is going to plead no contest to as charged to the count of indecent exposure. On a successful plea to that charge, then there's an agreement, a sentence agreement to a prosecutor's deferred. That's the court's moment.
That's correct, Your Honor.
That is correct, Your Honor.
May I have her sworn?
Raise your right hand. Do you solemnly swear in the front of the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Okay,
Do you state your name?
staring at it.
Okay. I just didn't hear it. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of indecent exposure. That's a misdemeanor, punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
I do.
You understand what a no contest plea is?
I do.
All right, two things about it. I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge.
Correct.
Understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court is going to treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea.
Lack of recollection.
And ma'am, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
Signed in advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
Doing this voluntarily and of your own free will?
Yes.
All right. And also because, well, I won't ask you that. Court has been handed and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-14872. Any objections to the court having reviewed that report?
None from the people.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to apprise you, if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
None, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea. In this case, defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2026, 12 noon. Bond will continue. All right, thank you.
Thank you, Your Honor.
What? Court calls case, People versus Kent Robbins.
Morning, Your Honor. Ready to cook for the people?
Ron Brown appearing on behalf of Mr. Robinson. The officer of the public defender does not believe a conflict exists between this honorable court and the office of the public defender. But if one were to arise, we would waive any claims that a conflict exists.
Your Honor, people similarly do not believe that any such conflict exists, and people make a waiver of any potential conflicts in the avoidance of all doubt.
Right, the court for its part also does not believe there's conflict either under the Michigan court rules or the cases decided thereunder, to the extent a conflict does exist, given the witness court will consent to. Your name, sir?
Robinson.
All right, I have before me a plea form that indicates that he's going to be pleading guilty as charged to the domestic violence. Is that correct?
Yes, sir.
That's our opinion.
I have it.
And you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. State your name, please.
Ken Robinson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that? Still wish to plead guilty?
Yes.
To that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form previously? Is that correct? Any question regarding any of those rights?
No.
Look at paragraph 5. You see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
Probation. Were you on probation at the time of this offense? Yes.
Yes.
Okay. I do have to advise you then that your entry of a plea in this case could be a violation of that probation. If it is considered a violation of that probation, you could be sentenced to the maximum allowable under that other charge by that other court. You understand that? Understanding that, you still wish to plead guilty to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're indeed guilty of this offense?
Yes.
On the date of January 14, 2026, at the location of, what is that location? 3000 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do regarding a Sharonda Stewart Moss that makes you think that you're guilty?
I hit her.
You hit her?
Yes.
All right. You did that on purpose?
Yes.
All right. You didn't have her permission to do that, did you?
Yeah.
You didn't have her permission to do that?
No.
All right. And who was she to you?
Girlfriend. Girlfriend.
Girlfriend? All right. Sir, if I accept your plea, I do have to advise you to commit misconduct between the time of my acceptance of your plea and the time of sentencing. That you would not commit misconduct as defined under the Michigan court rules. You would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
April 20th.
April 20th, 2026, 1 p.m.
Yes.
1 p.m. On its conditions will.
Your Honor,
Yes.
would you consider allowing him to use the phone at the jail, making outgoing calls?
Any response on the people? Like I've revoked it previously and
Looking at Mrs. Enda's notes, it looks like there were numerous phone calls that led to his phone privileges being revoked. I would ask that bond conditions remain the same, or at least give AP Enda time to respond to that change in bond.
Right. I think I'm going to do that. I'm going to deny that request at this point.
Yes, Your Honor.
Court calls case People versus Austin Shepherd.
Morning, Honor. Raymond Cook for the people.
Carolyn Foster Tucker on behalf of Austin Shepherd.
Austin. Your name? Austin Shepherd. Yeah.
Your Honor, this is the date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed this case, dismissed. That's on defendant's motion without prejudice.
Thank you, Your Honor.
Thank you. Thank you. Have a good one. You do the same. Court calls case of the People versus Taisha Wynn.
Morning, Your Honor. Raymond Cook.
Carolyn Foster Tucker on behalf of Tiaja Wynn.
Tiaja Wynn.
Thank you.
Your Honor, this is the date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed this case is dismissed on motion without.
Thank you, Your Honor.
Court calls case of the People versus Rashad Ahmad.
Morning, Your Honor. Raymond Cook for the people.
Morning, Your Honor. Sam Bernstein, standing in for the attorney of record, Charlotte Steffen, with and on behalf of Rashad Ahmad.
Good morning, Your Honor. That's with your permission, sir. Yes, sir. All right.
Your Honor, this time the people are unable to proceed.
Your Honor, we move to dismiss.
People being unable to proceed this case is dismissed on defendant's motion. That's without.
Thank you, Your Honor.
Thank you.
Have a good day. Go on.
Court calls case of the People versus Israel Diego Guerra.
Morning, Your Honor. Raymond Cook for the people.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Diego Guerra, who is approaching. And for the record, Mr. Diego Guerra, if you could, I was going to ask you to pull the mask down, but to state your name for the record, please.
Israel Diego Guerra.
Thank you.
Your Honor, this time the people are unable to proceed.
Defense would move the court to dismiss, Your Honor.
People being unable to proceed this case is dismissed. That's without prejudice on defendant's motion.
Thank you, Judge.
Court calls the case People versus Jacob Grammatico.
Your Honor, Raymond Cook for the people.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Grammatico, who is approaching. And Mr. Grammatico, once you're here, if you could state your name for the record, please.
Jacob Grammatico.
Thank you.
Your Honor, this time the people are unable to proceed.
Defense would move the court to dismiss, Your Honor.
People being unable to proceed this case is dismissed. That's on defendant's motion without prejudice.
Thank you, Judge.
Thank you, Your Honor.
Is that it for you?
That is, Judge.
Wow. No? Good seeing you, sir. Court calls the case People versus Caleb Kasham.
Morning, Your Honor. Raymond Cook for the people.
David I. Goldstein appearing on behalf of the defendant. Your Honor, I spoke to Mr. Kasham this morning. He put Monday's date in his calendar, but he didn't put today's date in his calendar. He's on a job site and cannot get here this morning. And as my knowledge, this is the first time he has failed to appear. So I'm asking we consider an adjournment in this matter.
Your Honor, the people were able to proceed this morning. The victim did appear. We have since excused him once we learned the defendant would not be here. I would leave it to the court's discretion. Bench warrant or return.
Let me add one additional thing, Your Honor. An offer was made today for the first time in this case, which obviously we would have had to discuss.
he gonna take that offer? I mean, I'm not carrying this over because he forgot to put it in. I gave 2 dates and everybody else remembered them.
All I can do is represent what I know to be true, Your Honor. As far as taking the offer is concerned, he doesn't even know the offer because I haven't discussed it with him yet.
Well, I'll be here pretty much the rest of the day. I don't know how long Mr. Cook's gonna be here. If he can get here, he can get here, but I'm not.
Well, I already said that to him when I spoke to him, and he said he's on a job site and can't get here.
Bench warrant will issue for defendant failure to appear. Bond will be set to amount of $10,000 cash as surety. I won't issue the warrant until Monday, 13th.
Thank you, Your Honor.
Court calls case People versus Kareem Omar.
Your Honor, Raymond Cook for the people.
Your Honor, Joe Simon on behalf of Mr. Omar, state your name, please.
Kareem Omar.
This is the day and time set for the conference, and people are able to proceed. It was an offer extended to the plead under 7694A. My understanding that offer has been declined. This is Ms. Dennis case. I can't represent that offer. Continue, guys.
Waiver.
So I was about to say.
All right. So you signed this waiver trial by jury?
I do, yes.
Pardon?
Yes, Your Honor.
You did? Okay, and you understand that you have a constitutional right to have this matter tried before a jury?
Yep.
And by signing this form, you're waiving that right?
Your Honor, yep.
All right. People also waive their right?
Yes, Your Honor.
Based upon the statement of counsel and defendant court will consent to have the matter tried before without a jury. Non-jury trial in this matter will be set for
April 29th.
Oh, thought this was the 27th.
Oh, I'm sorry. April 27th.
Thank you.
April 27th, 2026, 9 a.m.
Thank you, Your Honor.
Thank you. Bob, we'll continue.
Thank you.
Calls case People versus Ontario Robinson.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. Sam Bernstein with him on behalf of Mr. Robinson. Mr. Robinson, can you please state your name for the court?
Ontario Robinson.
Being separate final settlement. Well, it may be also considered sort of an adjourned motion hearing. This is the case where the law firm partner and necessary witness is quite unavailable. I have not been able to maintain contact with him since the last time over a month ago that we were able to establish contact. I don't know if he's going to be available in the near future. This has already been adjourned at least once on the people's request. I don't believe I can in good faith ask for another adjournment. I would just represent that when that trooper does become available, he would likely reauthorize the case if it were to be dismissed.
All right.
I understand that, Your Honor. It's just been like 5 months, so we would still move to dismiss.
At this time, because of those reasons, people are unable to proceed. You're moving to dismiss.
Yes, Your Honor.
All right. Case is dismissed. That's without prejudice. You understand that, sir?
Sir.
Okay. This case could be brought back. Thank you.
Thank you, and have a great day.
Same. Court calls case of the People versus Christopher Seelig.
Your Honor, Raymond Cook for the people.
Your Honor, David Rudow on behalf of Christopher Seelig, who is making his way to the podium now.
Your name, sir?
Christopher Seelig.
Your Honor, this is unable to proceed.
Your Honor, I would make motion to dismiss on behalf of defendant.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you very much, Your Honor.
Court calls case of People versus Aaron Bucko.
Conrad Silver on behalf of Pittsfield Township. Ron Brown appearing on behalf of Mr. Bucko, Your Honor.
Aaron Bucko. All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
All right, the defendant in this case is going to be pleading guilty to the charge of operating while visibly impaired, and that's the added count 2. Upon a successful plea to that charge, count 1 would then be dismissed. That's the court's full understanding of the.
That's correct. Yes, Your Honor.
All right, may I have him sworn?
I have. You solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yeah. State your name, please.
Aaron Bucko. Sir, it is this court's understanding that you're going to be pleading charge of operating while in. That is a misdemeanor, punishable by up to 90 days in jail, up to a $300 fine plus court costs. Court to order any rehabilitative services or community service the court deems necessary. Court order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency government. Understand?
Yes, sir.
Understanding that, you still wish to plead guilty
Yes, sir.
to that charge. How do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
Signed an advice of rights form, is that correct?
Yep.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights that are contained on that form.
Yep.
Yes. You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, sir.
Anybody threaten you or coerce you?
Sir.
You're doing this voluntarily and of your own free will? And also because you believe that you're guilty of this offense? September 7th, 2025, the location of Glencoe Hills Drive, Pittsfield Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
All right. Prior to operating that motor vehicle, did you consume intoxicating liquor? What'd you have and how much?
That I'm not exactly sure. 0.223 were. Yeah.
Were you stopped by the police or was there an accident?
He's passed out behind the wheel, but the engine running, so he was operating technically.
So is that correct, sir?
Yes, sir.
All right. And the police did arrive
Yes, sir.
and you were arrested. You were taken to the hospital for a blood draw.
Yes, sir.
And the blood draw netted results that your counsel just indicated. All right. You don't have any reason to dispute those blood test results, do you?
No, sir.
Take everything into consideration on that date and at that time. Do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, sir.
All right. Counsel, I do have to advise you, sir, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rule, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation recommendation. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendant's referred to Von Schwartz for alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be
April 29th at 12 noon.
April 29th, 2026, 12 noon.
Bond continue.
Bond will continue, sir. Stop down at my probation department before you leave the building and get it started.
And make sure you give them this, so they know you.
Court calls case People versus Frank Hearn.
Conrad Silver,
No,
yes,
Ron,
Pittsfield Township.
3 doors down.
Frank Hearn.
Frank Hearn.
What are we doing?
Plead double park.
That's correct. Yeah, parking. He has filed an appeal with the Secretary of State.
Mr. Hearn, do you admit responsibility to the fact that on July 26, 2025, Campus Parkway in Pittsfield Township, that you double parked the motor vehicle?
Yes.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and cost of $180. When can you get that paid?
Can you get 60 days?
Pay it by June 30th. 2020.
Thank you. Thank you. Thank you. You're welcome.
Court calls case People versus Mars and Morton.
Conrad Silver on behalf of Pittsfield Township.
Ron Brown appearing on behalf of Mars and Morton. Take it down.
Gotta take all that off.
Double parking. That's what we talk.
All right, your name?
Marley Morton.
Okay, what are we doing?
I'm gonna move to add count two double parking, Your Honor. Accept the admission and restoration charge.
How long you need to pay?
Well, sir, do you admit responsibility to the fact that on or about date of August 6, 2024, Packard Road, Pittsfield Township, that you double parked the motor vehicle?
Sir.
All right, court will accept that admission to count two. Count one is dismissed. Fines and cost of $180. When can you get that paid?
60 days.
Paid by June 30th, 2026.
Thank you. Thank you.
Court calls case People versus DeSure Bond Sanders.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Sanders.
Your name?
Glazer Bond Sanders.
Your Honor, this time the people are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you.
Yes. Court calls case People versus Robert Bowe.
Ron Brown appearing on behalf of Mr. Bowe.
Take care, Connor. Your name?
Robert Bowe.
Your Honor, this time the people are unable.
Move to dismiss, Your Honor.
Being unable to proceed, this case dismissed without prejudice. Thank you.
Thank you.
All right, as the dismissals continue, let's move along. We'll come back to Judge Simpson later, but let's go down to Florida, Wade Mercer.
Yourself to Mr. Hernandez and make sure he can hear you, sir.
Señor Hernández, buenos días. Soy Jordani Ricardo para que se pueda comunicar con el juez. ¿Usted me escucha?
Sí.
He can hear me, Your Honor.
Thank you. Mr. Hernandez, you're here because you've been accused of one count of driving with no valid driver's license.
Señor Hernández está aquí porque se le acusa de manejar sin licencia de conducir válida.
Correct.
Correct.
There is probable cause in the complaint, and I'm going to appoint the public defender's office to represent you.
Hay causa probable en la denuncia y le asigno al abogado de oficio para que lo represente.
Please listen to your attorney, Mr. McDaniel.
Por favor, escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Hernandez. We're going to enter a plea of no contest to the charges as listed with the understanding he'll be sentenced to 2 days in jail, credit for 2 days.
Su señoría, he hablado con el señor Hernández. Él se va a declarar no me opongo ante los cargos, entendiendo que se le va a condenar a 2 días en la cárcel con crédito por 2 días.
There'll be a $400 fine, which will be a civil judgment against his credit rating.
Tendrá una multa de $400, que sería un fallo civil que iría en contra de su crédito.
Understands that any plea can be used against him in immigration court.
Él entiende que cualquier tipo de acuerdo en un caso penal se puede usar en su contra en el Tribunal de Inmigración.
You understand that there's an ICE detainer and ICE has to pick him up in 48 hours from today.
Él entiende que tiene una orden de retención de inmigración y que inmigración tiene que recogerlo en menos de 2 días a partir de hoy.
Mr. Mitchell's that agreeable with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? Lo está su señoría.
Mr. Hernandez, did you hear that agreement?
Señor Hernández, ¿escuchó el acuerdo?
I think he said yes. Did he say yes, Mr. McDaniel?
He said yes.
Oh.
Mr. Hernandez, is that the plea you would like to enter?
Señor Hernández, ¿es ese el acuerdo que desea aceptar?
C, he said C. Speak up.
Yes.
Mr. Hernandez, I'm going to accept your plea of no contest to the charge of driving with no valid driver's license.
Señor Hernández, acepto su declaración de no me opongo ante el cargo de manejar sin licencia de conducir válida.
Withhold adjudication of guilt and sentence you to 2 days in the Jackson County Jail.
Le suspendo el fallo de culpabilidad y lo condeno a 2 días en la cárcel del condado Jackson.
Give you credit for the 2 days you've already served.
Le doy crédito por los 2 días que ya ha cumplido.
And impose court costs and fines in the amount of $400.
Y le impongo multas y costas por la cantidad de $400.
That $400 will be reduced to a civil judgment.
Esos $400 se reducirán a un fallo civil.
And Mr. Hernandez, as mentioned, the Immigration Service does have a detainer on you.
Y señor Hernández, como se mencionó, el Servicio de Inmigración tiene una orden de retención contra usted.
So they have to pick you up within 48 hours of now.
Así que ellos tienen que recogerlo en un plazo de 48 horas desde este momento.
Do you have any questions?
¿Tiene alguna pregunta?
Say no. I need you to answer out loud, Mr. Carter.
Necesito que responda en voz alta si tiene una pregunta o no. No.
No. Okay.
No.
Have a good day, sir.
Que tenga buen día, señor.
Thank you, Mr. Carter.
Thank you, Your Honor.
Madison Pearson.
This is the second, yes.
Ms. Pearson, good morning. Ms. Pearson, you're here in case 26-82 CT, charged with one count of driving under the influence and one count of refusal to submit. Ms. Pearson, you got a new charge, an alcohol-related charge in Bay County. I think Mr. Meadows has been able to resolve that, and Mr. Meadows is doing everything he can to try to get you out this morning. Ms. Pearson, I'm concerned about the alleged alcohol issues, as well as your age. You go from having no charges your whole life within a couple of weeks. Now you've got 2 charges pending in a very short period of time. Both of them are alcohol related. So Mr. Meadows is here. Let's listen to where we stand in the case, and then we'll see if you have any questions. Mr. Meadows.
Judge, what we would propose is a plea to 11 months, 29 days probation, $978 fine, DUI school, 50 hours public service work, counseling as directed by probation officer with a special condition, Judge, that she has to receive an immediate first available evaluation by a substance abuse specialist to determine whether or not she needs inpatient or whether outpatient therapy would be sufficient, and that she's required to follow up with whatever recommendation that they make. In the meantime, until that evaluation is done and communicated to the probation officer, that she be required to live with her mother, Courtney Cockrell, and that she be allowed to go to work, but anything other than work or church, that she has to be accompanied by her mother, Courtney Cockrell, until that evaluation is completed. And reported back to the probation officer, and the court makes any further order required. Restitution in this case is appropriate, and the court would withhold jurisdiction, reserve jurisdiction on the issue of the amount of restitution until additional documents can be provided to the state. Minimum DL suspension, and I believe that incorporates all of what we are proposing as a resolution, Judge.
Thank you, Mr. Meadows. Mr. Mitchell.
I think you covered I think Mr. Meadows pretty much covered everything, and that is agreeable with the state. We'll leave it up to the court to decide what to do from this point forward.
Mr. McDaniel. Judge, I think the fine is $1,078. I've also got her to go ahead and sign the plea waiver form, went over the plea waiver form with her to waive a right to jury trial and call witnesses. Mr. Goodson, is that the plea to both charges? So, Ms. Pearson, I know that part of this may be new to you, so I want to make sure you clearly understand. My concern with just the probation, with a regular DUI probation, is the recent DUI. But Mr. Meadows has pointed out several things in your favor. Number one, you had no prior history to your attention. Number three, your age and your employment. So those are all helpful. 3 and 4, those are helpful things. My concern, the reason we're doing this is I want to make sure that there's not an alcohol problem here that's outside of your control, that you just can't stop. So that's why you'd be essentially on house arrest, except for work, church, or in the presence of your mother, until you get the alcohol evaluation. Now, if the evaluator says you've got to go to inpatient, then that's what you've got to go. If the alcohol evaluator says that outpatient counseling will suffice, then that's fine. I'll need a professional to say that. And hopefully, I'm going to direct that you get that evaluation done within 30 days. So hopefully we can get that evaluation done. And I need you, no parties, no hanging out with friends, certainly no consuming alcohol And we got to get this thing under control before it gets worse than it already is.
Yes, sir.
So I know you may disagree, but the reason I'm doing all of this is because I'm concerned about your welfare. Do you have any questions at all about this plea agreement?
No, sir.
Do you live with your mother anyway?
Kind of. Mostly
Okay.
with my mother, yes.
Where else do you live other than with your mother?
In Panama City with my grandmother.
Okay, so you're going to be at your mother's house at least until the alcohol evaluation, and we'll go from there. Any questions
Yes,
about
sir.
that?
No, sir.
Ms. Pearson,
Actually,
is
yes,
this?
I do have a question.
Okay, go ahead.
If at any time I need to go to my grandmother's house, would my mother have to come with me?
Absolutely. Unless,
Okay.
yes, that's what house arrest means. Yes, she would.
Okay.
Now, if you contact the probation officer and say, you contact your probation officer, Mr. Goodson, and say, I've got this situation, Mr. Goodson can obviously make exceptions, but I don't need you to call him every day asking you to go to grandma's house because he's just going to say no. It's not
Yes,
gonna
sir.
happen. Okay, so hopefully within 30 days, this evaluator comes back and the evaluator tells us either you need inpatient or you need outpatient. Either way, we're going to go with what that evaluator says, but you're awfully young to have 2 alcohol-related charges in such a short time period. Any
Yes,
questions
sir.
at all?
No, sir.
Mr. McDaniel?
Steve, you mind if I ask her a question real quick? And I'll just mute it.
What is
It's involving around her employment. She works in Panama. I mean, how's this going to, she works at the airport. So kind of, is that the house arrest? Is that going to affect her going to work in Panama or?
She lives in Panama.
Where mother lives, doesn't live in Panama though. Mother lives in Mariana. Isn't it, or?
My mom lives in Alfred, Florida, Compass Lake.
Okay. So
But-
if you still have your job, you're free to drive to and from work, but that's it. I don't want you going anywhere else, hanging out with no friends, whatever happened in Panama City recently, you got arrested for stopping, all that kind of stuff. Any questions about that, Ms. Pearson? If this doesn't work for some reason, you let me know. But, if you say that you can do this, and this is what we're going to do.
Yeah, and Judge, she's not going to be able to drive until she gets this administrative suspension resolved.
So the job may be an issue unless someone can take you to and from work. Okay. Is this what you want to do?
Yes, sir.
Mr. Goodson?
Just for clarification, so 11 months and 29 days on the DUI, 6 months on the refusal. I know she's gonna be a judge guilty on the DUI. I didn't know about the refusal.
Yeah, I want to withhold and no priors other than what she had recently. So thank you. Ms. Pearson, I'm going to accept your plea of no contest to these 2 charges, driving on the influence and refusal to submit to breathalyzer. Ma'am, I'm going to withhold adjudication of guilt on the refusal. I have to adjudicate you guilty on the DUI. So I'm going to impose a standard court costs and fines for a private attorney case, which are $100 less because there's no public defender fee, and that amount. No. Oh, so they'll still get it if they're arrested. So you're right. $1,078 court costs and fines. I think I already said the 6-month probation on the refusal will be concurrent. The standard conditions of every probation plus the following special conditions: successfully complete substance abuse counseling as directed by the probation office. If you enroll in DUI school within 60 days, that's going to constitute perhaps all of your substance abuse counseling other than what the evaluator recommends. 50 hours of public service work are also required by state law. You have the right to purchase those under state law. I do recommend the minimum driver's license suspension. I'm reserving jurisdiction on restitution for 60 days. That means if you don't agree to a restitution amount, Mr. Mitchell has to have a hearing or schedule a hearing within 60 days to see if there is any restitution on the DUI. So that is she pleading to basic DUI or is she pleading to DUI with property damage? Since there's restitution referenced, you can't have restitution on a regular DUI.
I would say DUI with property damage.
I think that's the.
If you're reserving restitution, it pretty much has to be. So if you're pleading to DUI with property damage, that carries a maximum of a year in jail. The reason that's important is if you violate probation, you need to understand that. Ms. Pearson, do you understand that?
Yes, sir.
I'm not saying I'd give you a year in jail, but I certainly might, depending on how you violate, if you violate, and hopefully you won't. So you've got
No,
30
sir.
days to go for an evaluation. Evaluation's got to be by a certified or approved alcohol treatment specialist. And until that evaluation comes back, until the results come back, you've got a condition that you live with your mother unless there's an exception made by the probation office. And you can only leave the home for work or church purposes unless you're accompanied by your mother. So if you're accompanied with your mother, that's fine. Y'all can go out and eat or whatever. Ms. Pearson, I just need you to strictly follow these rules because I don't want you to violate. I don't want to see you in 2, 3, 4, 6 months with you having alcohol in your system, because what's going to happen then is you're going to be in jail for a long time. And I don't want that to
Yes,
happen.
sir.
Ms.
Yes, sir.
Pearson, let me tell you what's going to happen next. They're going to let you get dressed. They're going to let you use the phone if you wish to set up transportation. Then they're going to bring you to the courthouse. The reason for that, when I say they, I mean the jail. The reason for that is because the courthouse is where the probation office is at. When you get here, you'll meet with Mr. Goodson. Mr. Goodson will go over the probation order with you. Mr. Goodson will give you a copy of all the rules in writing. He will give you a chance to ask any questions you have, and then you'll be free to leave. So, Ms. Pearson, the number one condition is no alcohol. That's both your charges appear to be alcohol related. So no alcohol is the number one condition you got to follow.
Yes, sir.
And as long as you do that, your life history makes me think, as long as you follow that condition, you'll be able to follow all the others.
Yes, sir.
Ms. Pearson, do you have any questions?
No, sir.
Mr. Meadows, have I missed anything, sir?
No, Judge, I believe you've covered it.
Mr. Mitchell? All right, Ms. Pearson, we'll see you at the courthouse in a little while, or Mr. Goodson, we'll see you in a little while. I wish you the best, ma'am.
Okay, thank
You
you.
never heard back from, thank you. You never heard back from Ms. Colbert, did you?
So. let me see. She said she's waiting to hear back from.
Okay. Well, it'll be good. It'll be good to know for future reference.
Yeah.
All right. So ladies and gentlemen, that takes care of individuals who had friends or family or an attorney present. So we'll go back to the top of our docket, which is Bruce Mims.
Thank you, Judge. My bad.
Yes, sir. Thank you, Mr. Meadows, for coming up.
Wait, there's your copy actually right there.
Mr. Mims, good morning. Mr. Mims, you're here because you have an out-of-county warrant out of Brevard County. I'm going to ask the jail to double check this. But what it looks like to me is you have a child support matter with a $660 purge. So I know that's kind of trivial compared to your much more serious criminal charge, but you do have a child support warrant out of Brevard County, and you have the right to be made aware of that. Anytime your bond or your purge changes like it is today, you get the right to use the phone to notify friends or family. Any questions, Mr. Mims?
I just don't know if anyone's aware that I've been here for 2 years. So there's no way I was able to make any payments at all. I've been here for the last 2 years.
I think he's been in custody.
Corporal, is that right? He's been in custody 2 years on this trafficking case?
Yes, sir. He has. I told him to write the courts down there. Just let you know that warrant was for $600. I know it's a bad copy. Looks like $660, but it's $600 purge.
Yeah, mine clearly says 660. Now, they may have made a mistake in it. I'm not saying you're wrong, Mr. McDaniel, but it's not, it says 660.
I'm thinking the rest may be transportation costs. That's why it's 660. They do a lot of the county transportation costs. Well, the actual warrant is 600, so.
Okay, I'm just looking at the teletype. I don't have the warrant. The teletype says 660, but they may have included transportation costs, and you're right. They may not be able to do that. So, Mr. Mims, that is concerning that I don't know that the child support, first off, it's concerning that you're there for 2 years still, waiting on the resolution. That's concerning.
I agree.
Fortunately, it's not my case. So I have no knowledge of why that may be the case. Regarding this, the matter in the child support matter, Mr. McDaniel, do you have someone you could notify down there by email or that Sissy can notify just to make them aware of that?
I can. I mean, I can notify them.
Thank you. So Mr. McDaniel's going to notify them. Mr. McDaniel works part-time with some child support related stuff in another capacity, not in his role as an assistant public defender. So I'm asking him to notify them that you're in jail. Obviously, you can't pay child support while you're in jail, and make them aware of this in writing. And then I'll ask you to get you a copy of that, so you'll be know whoever he notified. So Mr. Mims, it's there. If the criminal case gets resolved and this hold is still on you, I don't know that I would hold you just for this under these circumstances. So Mr. McDaniel and Mr. Mims, I don't know what will happen to the criminal case, but if it gets dismissed or if you get found not guilty, he needs to come back to first appearance the next day so we can check on this.
He has been given a bond in this case. He
can't make it, so he's in jail, right?
Yeah.
$50,000 bond. So, Mr. Mims, if you're still there and the criminal case is resolved, again, by not guilty or dismissal, I'm asking the jail to bring you to first appearance the next day so I can deal with your concern. If you go to prison on this charge, obviously, it doesn't matter. Any questions?
No, I appreciate it, Honor.
Yes, sir. Wish you the best.
All right.
Daryl Bucks, Mr. Bucks. Mr. Bucks, good morning. Mr. Bucks, you're here for the charge of violation of probation. I think we kind of anticipated this. It looks like there's a no bond warrant. It's been issued by the circuit judge, Mr. Bucks. What I'm going to do, is I'm going to go ahead and arraign you on that charge because I want to get you a lawyer appointed if you're asking for one. Mr. Buggs, would you like to have an attorney appointed to represent you?
Yes, sir.
I'm going to appoint the public defender's officer to represent you, Mr. Buggs. Listen to Mr. McDaniel. We'll see if you have any questions in just a minute.
Your Honor, we're going to enter plea of not guilty. Yes, to set this on the April 23rd court docket, and advising that the attorney from the public defender's office will come by and visit him prior to that hearing.
April 23rd, Mr. Mitchell, anything?
No, Your Honor.
So, Mr. Buggs, the attorney will see you before your court date. And you'll see Judge Garcia and make sure you tell your attorney that you've resolved your local charges, and hopefully that'll help get that resolved. Mr. Buggs, any questions?
No, sir.
All right, sir. Wish you the best. We have James Harris.
Yes, sir.
Mr. Harris, good morning. Mr. Harris, you're here for the charge of driving under the influence in case 26-18. It's listed as a failure to appear charge. The public defender's officer represents you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I swear to Mr. Harris, we're going to enter a plea of no contest. The charges listed. You understand he's sentenced to 4 months in the county jail. You have 7 days jail credit. There'd be $1,078 in fines. He has waived his right to a jury trial and call witnesses, and this will resolve this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor. I know after he was arraigned on this one, I filed an amended information and the charge of refusal to submit. For purposes of today, the state will move to dismiss count 2 on that and plea him to the DUI.
Okay. And Mr. McDaniel, I assume that's okay with you?
Great. I didn't realize that, but yes, that's correct.
Thank you. And Mr. Harris, I may have already asked you this. Is this the plea you would like to enter, sir? Mr. Harris, is this what you want to do?
I think he muted it real quick.
Yes, sir.
Thank you. Mr. Harris, I'm going to accept your plea of no contest only to count 1, driving under the influence. Count 2 is being dismissed by the state. It's case number 26-18 CT. On that count 1, I'm going to judge you guilty, sentence you to 4 months in jail, $1,078 court costs and fines. State's dismissing count 2, and the total credit for time served I did not write down, Mr. McDaniel.
7 days.
7 days credit for time served. Mr. Harris, all that means there's no probation involved in this sentence. You finish this jail sentence, sir. This is all behind you. Mr. Harris, do you have any questions?
No, sir.
Wish you the best, Mr. Harris.
Thank you.
Yes, sir. We have Anthony Keith. Keith, good morning. Mr. Keith, you're here for 2 charges of case 25324, 2 case numbers. That first case number is grand theft, exploitation of elderly, and fraudulent use of a credit card. The second case is 25-346. Those are fraudulent use of a credit card, exploitation of elderly, and grand theft. Essentially, it looks like 2 counts of each charge, 6 total felonies. It's a failure to appear warrant where you've accused of not appearing in pretrial court in front of Judge Garcia. So there's a no bond warrant issued, Mr. Keith. You're going to be held with no bond until you can get over to circuit court and try to get this case resolved. I'll ask Mr. McDaniel to notify your attorney in felony court of the no bond status. Mr. McDaniel?
Judge, how much is the bond? 500 cash use. So his previous bond was $500 on each count. Madison County come over and picked him up with an order to pick him up, and we left a detainer with them to bring him back, but they sent him to prison, and now he's coming. They just shipped him back from prison here. So we just asked the court to maybe go ahead and use some and ask the court to reinstate that previous bond, which I think is $1,000 cash bond. And I haven't looked myself, but I was told what it is. 3,000 cash bonds. I'm sorry.
Your Honor, if I may.
No, hang on just a second. Let me look up the case before. I'm glad to hear from you, but give me a second here. Yeah. New information.
Couldn't text all that this morning.
No, that's fine. It's just, I don't mind at all. I just want to make sure that I know as much information as I can before I change a no bond warrant from another judge. Okay, so I'm seeing first appearance back in July, information filed, and then allegedly stipulated the order releasing defendant from the Jackson County Correctional Facility and transferring to Madison County to answer pending charges. So let's see what the stipulated order is. I've never seen an order like that. So let's see what it says. What it says is that Assistant State Attorney, Mr. Gill and Mr. John Young Roberts have stipulated that he's got pending charges and he's got a violation of probation in Madison County. The defense counsel says the Madison County charge should be addressed first before the Jackson County charges. The state has no objection to releasing him. Therefore, the court's granting the authority. Madison County shall be notified that the defendant is available for transport. Okay, so that would have been in September of 25. And then it was set for a pretrial in December of 25, and the capias was issued January of 06.
January 6, 2026.
January 6th. So let me go to the Florida Department of Corrections website. Your understanding, Mr. McDaniel, is he actually went to prison out of Madison County and he's already out. Is that right?
Correct. Well, I think he was in EOS yesterday. So.
Yes, sir. That's not what the order from the 6th says, at least according to Judge Garcia, from what I'm looking at.
All right. Mr. Keith, I'm looking at the Department of Corrections website. It shows a detainer from Jackson County. It shows you in custody 10/9 of 25, out of custody 4/9 of 26. So you're out of custody yesterday. All right. So I kind of got a little bit of a better idea. Mr. Mitchell, what were you about to say?
So I misread it, but there was that order of revocation of release with directions to clerk filed on the 6th. Released him to Madison County to answer dependent violation of probation charges. The court anticipated that Madison County would resolve the instant case at the time of resolving the Madison County cases. Unfortunately, that did not occur, and the defendant was sentenced to serve time in DOC. So he did serve time in DOC. This issue was brought to the court's attention on December 16th of 2025. At the time, counsel for the state and the defendant were both present, ordering a judge. The defendant's release previously granted on September 7th, 2025 is revoked. That's the last thing I'm seeing that happened in this case.
So she revoked the release, but that doesn't mean he's not entitled to a bond. Revoke the release means I just got to get a warrant out there, so there'll be a detainer on him. That doesn't change his bond status.
Yeah.
Is there any evidence the state has that he's violated the condition of his bond?
Not
Such that his bond will be revoked.
At this time, I have not seen anything.
Mr. Blunt, you're shaking your head. Yes, you think he's entitled to a bond too? I think Mr. McDaniel may be right. Mr. McDaniel, you think he's entitled to a bond, right?
We were just asked to reinstate that previous bond, Your Honor.
I think
Yeah, I mean,
I think he's right. I think that's the thing to do is you get Mr. Judge Garcia issued a warrant, so there'd be a hold on you to get you back here. But I don't think that means that you're not entitled to a bond once you get back here. So it's really not a failure to appear warrant. The clerk's office did a failure to appear for pretrial conference, which is really not what Judge Garcia's order says. So I'm going to interpret it in your favor. I think what she wanted was a warrant issue to get you back here, not necessarily for you to have no bond. So it looks like in case 25324, you have a total cash bond of $1,500 cash only. That's 25324. And in 346, I think Mr. McDaniel thinks it's the same cash bond. We're going to double check that. It probably is the same cash bond from first appearance. And it looks like it's $1,500 cash also. So you've got a total cash bond of $3,000 cash, the exact bond that was set for you for first appearance before you went to Madison County. Mr. Mitchell, anything else you want to put on the record on that one?
No, Your Honor.
Mr. McDaniel, anything else?
nothing else, Your Honor.
Mr. Keith, any questions?
No, Your Honor.
All right, sir. Wish you the best.
Thank you.
Whatever was originally on the first appearance. So let's look and see. Nothing on the jail sheet. That doesn't always mean anything. So out of abundance of caution, I need to do a condition of no contact with the alleged victim in that case. Corporal, there's nothing wrote on the jail sheet. I find that
you did put no contact with the victim on there.
So it's not on the jail sheet from first appearance, but it's pretty common that'll get missed. So please let him know there's a condition, no contact with the alleged victim in that case. Victim or victims, since there's two case numbers. That brings us to Wayland Kramer. Mr. Kramer, good morning. Mr. Kramer, you're here because you've been accused of one count of domestic violence battery. There is probable cause in the complaint. Mr. Kramer, the history I've got shows no prior criminal history. Is that correct, Mr. Kramer?
Yes, ma'am. Yes, sir.
Okay. Mr. Kramer, you are 22 years old
Yes,
and you're
sir.
unemployed. Is that right?
Yes, sir.
How do you provide for yourself? Are you a student or what's your status?
I mean, I got a side job.
Well, how
I'm
do
a
you, what do you mean
landlord.
a side job? Are you unemployed or do you work? Which is it?
That's your direct question. I mean.
Cash. I mean, I get paid cash.
Okay, then you're working. Tell me.
Yeah, I work.
Where do you work at?
My landlord.
All right. So do you live in the same residence with the alleged victim?
Yep.
All right. I've got enough information. Mr. McDaniel, anything?
Your Honor, we just asked for a conditional release and,
Yeah, he's not getting a conditional release.
Oh,
I appreciate it. Mr. McDaniel. His attitude's terrible. He doesn't have a real job, it appears. And I'm concerned about the allegations in the complaint, which are pretty serious.
yes, sir. I don't think, just for the courts, I think he's just kind of quiet talking here. I don't think he's meaning to be, rude to the court. But we understand whatever kind of release option, maybe a cash bond option, Your Honor, if that's acceptable.
Mr. Mitchell,
No objection to a cash bond.
do you have somewhere else you could live other than where the alleged victim lives? Let me explain what I mean by that. There's going to be a condition of no contact with her. So
Yes, sir.
even if I were to consider a conditional release, I would only consider that if you had somewhere else you could go. Do you have somewhere else you could live? And before you answer the question, I'm going to need to know where.
Yes, sir.
Where?
Pike Pond. My grandfather, Robert Locke.
And where do you work at again?
This is my landlord.
What's his name?
Miss Pat Route.
Pat Route. What do you do for her?
Just fix the trailers up for
How much does she pay you?
her. It knocks off my rent.
Knocks off your rent. But how do you buy groceries? How do you support yourself? I mean,
Oh,
you
she's my baby mama. She got food stamps. She's
how
got
do you
2
pay
kids.
electricity bills?
Yeah,
Mhm.
that's not a real job. I'm going to set your bond at $2,500 cash or surety. You have a condition, no contact with alleged victim. You get a chance to use the phone, sir, in a few minutes to post the bond. I wish you the best. We're also going to ask the jail to give you a notice for your court date. When will that be? April 27th will be your court date, sir, at 9 a.m. Mr. McDaniel, if he's still there next week, I have no problem you bringing him back. Let's see if we can make some progress, but it doesn't look like he has a real job. That's concerning.
Yes, sir. Understand,
Thank
Your
you.
Honor. He
Thank
may
you.
have I noticed, I just couldn't help but notice they filed a action against him and his girlfriend on, truancy case, so they may have a truancy case about to be served on them. I seen it was filed, but I hadn't seen them service on it yet.
So, Mr. Mitchell, if you can take a look at that case, the complaint, the alleged victim there wouldn't even be probable cause if it wasn't for the fact that a third person allegedly saw the whole thing. But she was not very cooperative and did not appear to be very truthful if the witness's version is credible.
Yeah.
So you may or may not be able to go forward with it. So, Mr. Kramer, if you post the bond, you'll be released. If not, I'll see you one day next week, sir.
Yes, sir.
You did say no contact with the victim.
I did say absolutely no contact with alleged victim. Joshua Philman. Mr. Philman, good morning. Mr. Philman, you're here because you've been accused of one count of obstructing an officer without violence. Mr. Philman, there is probable cause for the charge. I'm appointing the public defender's officer to represent you. Mr. Philman, please listen to Mr. McDaniel, your attorney.
Yes, sir.
Your Honor, Tammy is here today. I don't have to see him yet, although I haven't spoken with him and he's definitely, I mean, he does do it. He's going to qualify for a Baker Act. So Tammy's got to see him first. So that's all I have, Your Honor.
Mr. McDaniel, your text, I learned some information this morning from your text or your email. So I thought the county had a contract with Life Management, and because that contract, Life Management did evaluations, and that was included in the contractual rate, but that's not accurate, or correct?
Not completely accurate. So if it has to be done on an emergency basis, it's, when someone comes in, they need to be seen the next day, it's $200 fee.
Okay.
And they got to pay it on each one that happens.
Okay.
And,
So is the corporal still in there?
Yes, sir.
So Corporal, here's my question. I don't necessarily think that Mr. Philman is an emergency basis, but I do want him evaluated. So tell me the timeline difference between if I ask for an evaluation today versus I just ask for an evaluation whenever they're out there?
Okay, it's my understanding that the only time we do emergencies is if they attempt suicide, we have to call them after hours. If they come in and there's a possibility that we're gonna, Baker Act them, then she just sees them when she comes in.
Okay. And Mr. McDaniel, is if she sees them when they come in, Mr. McDaniel, is that an extra fee for the county? Is your understanding?
I believe it's just the $80 fee then, when it's just regular when they come in to see them.
Okay.
And the 120 is the, that's what Chief was telling me a while back. And I confirmed with him this morning, but I didn't get all the details. I was trying to get in here real quick, so it could be, like you're saying, after hours. I'm not quite sure.
I know that you've been kind of trying to address this issue for a couple of years. It appears that with smaller municipalities, it appears this case is a great example. They get a call for a Baker Act. They get out there, the person resists them somewhat, which you kind of would anticipate in a Baker Act call. Rather than Baker Acting them, the officer changes gears and decides to make an arrest. And that's essentially what the complaint says in this case. And I know that you have a theory that has to do with them not having to transport them, that it then becomes the county's responsibility to transport them. And that may be some substance to that, I'm not sure. But Mr. McDaniel, is that kind of your view on what we have here?
That is, it's costing the county taxpayers, and that's always been my concern is costing county taxpayers for it. But that's I'm trying to make.
I know it's difficult when a municipality only has one officer because that transport can take 2 or 3 hours. But I don't know that arrest them for this kind of charge is the best solution either. It's pretty clear based on the complaint, Mr. Philman, his crime was secondary, or his alleged crime was secondary to alleged mental health crisis. Mr. Mitchell, what's your thoughts?
We're in agreement with the court on that. We'll leave it up to your discretion.
I guess my question, Mr. McDaniel, is if I don't mind setting him a small bond, but I don't, if I grant him an ROR, does that in turn make it an emergency on life management? I don't want to make the county pay extra money just because I grant him an ROR. I may just set him a small bond and let life management do an evaluation. Having said that, if they say he needs to be Baker Acted, I'm fine with that. I just can't let him out on the street if that's the case.
My suggestion would be, Your Honor, is to create a small bond because it is Friday today. And also in that bond, it says if life management determines when they see him on a normal basis that he qualifies for Baker Act, then that would transfer over to ROR to go to Baker Act.
You know what? I think that's a creative and good solution. I wouldn't have thought of that. I think that's a really good idea. Put in the bond. If he qualifies for Baker Act, then automatically he would qualify. It would be reverted to an ROR. Mr. Mitchell, what's your thoughts?
No objection to that.
I'm going to set you a $500 bond, but there's going to be a condition of the bond. If you're evaluated by life management and they determine that you qualify for, or law enforcement can do an evaluation also. They could have done it yesterday. If you're evaluated by law enforcement or life management and they determine you qualify for Baker Act, then upon that Baker Act being filled out, then this will be converted to an ROR. That means the jail doesn't have to keep you and make you post bond. They don't have to keep you till Monday. They can go ahead and let you go today if law enforcement or life management say you need to go today. Mr. Philman, any questions about any of that?
This officer has Baker Acted me like 6, 7 times. I've had to walk from Panama City. I've had to walk from Tallahassee. It's like he's playing football with me.
Well, this won't be the officer doing it this time. If the life management says that you don't qualify for Baker Act, then you've got a bond set. If life management says you qualify, then that's now somebody else saying that there needs to be some underlying mental health issues that got to be addressed. Okay?
Yes, sir.
Please give him a notice for his court date, which will be
27th.
April 27th. Mr. Philbin, I wish you the best.
Yes, sir. Thank you, sir.
Yes, sir. I like that. That's a creative solution, Mr. McDaniel. That's a good solution, I think. Way it's not an emergency, but if they get the evaluation done today, he can go today.
Yes, before they told me it was 200. I thought it was 200 on each of them, but I didn't realize it was only on an emergency basis. So he was just telling me. So, but I think it's 80. I know it was $80 for the normal one. So then 120, I guess, emergency basis. Yeah. So I appreciate you, Your Honor.
Mr. McDaniel, anything else from the public defender's office this morning?
No, Your Honor.
Mr. Mitchell.
All right, as they wrap up there, let's go to Texas. Jefferson County, Judge Stevens.
Okay, we have an 18-3-0-0-1-3. You, Willie Cowart Jr. And there was a hearing held about a year ago, and you pleaded true to some reporting issues, and you have been on probation since 2019. And this is an update on status, how he's doing, I guess, from probation. So I guess the question is, how is he doing?
He's doing good. Last time we were here, you discussed possibly early termination for him. You just had the stipulation that he test negative for methadone moving forward. So he submitted 2 drug tests, one on 220 and one on 320. Both were negative since our last hearing.
Good job.
I also believe the last status hearing we had in January was to make sure that he had paid all restitution. And it's my understanding that it's all paid at this point.
Okay. So, what shall we do?
Up to you, Judge.
Actually, it is, but I'd love to hear what everyone has to say. I know what the defense says, but y'all are, we 2 advocates, but actually at the end of the day, probation is the neutral person. And what do you think?
Well, he's done what's required by the courts to him for the most part. And so if that is something that everybody is on board with, I'm okay with early termination.
Okay. What do you think, Mr. Cowart?
Yes, sir. I agree with you.
I'd have been shocked if you'd have said otherwise. You obviously, your mental faculties are sharp today, obviously. What do you plan to do now?
Well, sir,
when and if this gets off your back?
yes, I plan on getting a stable income. And just,
Doing what?
Stable, that's okay. That's kind of up in the air, Your Honor. I broke my back in 2 places, so the work I used to do is kind of
no more heavy lifting?
Yes, sir. So I got to work my mind instead of the body. So it's kind of taking just forward. So it's kind of got it.
So you're gonna, I guess, apply things like that?
Yes.
Okay, well, at least you'll be able to put on your application, you're not on probation.
Thank you, sir.
Okay, we'll get a termination of probation over to me and I'll sign it.
Thank you, Judge.
Good luck, Mr. Cowles. I see Nakia Lewis was reset,
Yes,
right, Brent? Okay. And Thaddeus Jolly, this was reset to next week, is that right?
Yes,
make sure it's working.
right? Yeah, they're trying to.
Hey, not so fast, John. I've got there's it looks like this is an add-on Christopher Chambers. That's you.
I'm running a full set to make those and they didn't bring them over, so we couldn't do anything with it even if we wanted to. But
What were we gonna do?
He was somebody
who was tried to plead this past week, and there was always some issues of competency, and he kind of acted up a little bit here, and you said no to the plea to set it for a hearing and told us to be ready by Friday.
So you should have 2 dismissals, one for the MTRP and one for the new case. In your queue.
Yeah, it's
Well,
wherever your tablet is.
yeah, I don't know where it is. Do y'all have it?
That's somewhere.
Yeah, how about you? Did y'all check under the chairs? Is it under that guy that's laying down?
Yeah, you know, in this court, it may have fell.
Yeah,
we may not be.
Under him.
Right here.
Okay.
There should be a new case in emotional abuse.
Yeah.
I guess you're still on probation.
You can't make this stuff up. It just really happens in this room. Okay, it looks like 2 cases. 24 CR 747, 24 CR 2317, each style, the state of Texas versus Christopher Chambliss. There are motions to dismiss in each case without objection.
No objection.
I shall sign these on this 10th day. Of April.
I got one line in there. Be careful. Yeah, they said, I'm gonna miss you, Brent.
Yeah, wait till you leave and see what they say. Good, that's good, wise.
On YouTube.
You can watch it.
All right, well, it seems like it's going to take some time for them to rack up another contestant, so let's go back to Judge Simpson for a little while.
No answer, Your Honor. Can you pass?
No. Bench warrant will issue for defendant's failure to appear. Bond will be in the amount of $10,000 cash. Warrant will issue immediately. Court does call the case People versus Austin Ingram.
Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Ingram.
Your name, sir?
Austin Ingram.
Thank you.
Proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without.
Take care.
Thank you. Court calls case People versus Alicia Calloway.
Morning, Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of Ms. Calloway, Your Honor. May I approach with the prosecutor once she introduces herself? We don't need to approach.
All right.
Introduce yourself.
Alicia Calloway.
Thank you.
People are unable to proceed.
Move to dismiss, Your Honor.
For being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Thank you.
You're free.
Court calls the case People versus Carlos Mack.
Morning, Your Honor, Raymond Cook for the people.
Ron Brown appearing on behalf of. Your Honor, may we approach very, very briefly?
Very briefly.
You have us driving left. Driving left.
While we're waiting for Judge, Barbara just asked in the chat, is Dungeon Court running today? Yes, they are, and we will likely go there during the 4th hour.
Yes.
Sign right there for me.
I was still get them there.
Yeah.
Yes, I was trying to.
Yeah, you're trying to get it, but
Yeah.
it's better than what you originally charged.
I was, oh.
Here's your receipt showing. But you,
From I have it, yeah, no. Defendant will be pleading guilty to an added count 2 of no operative person. Misdemeanor punished by up to 90 days in jail, $100 fine plus court costs upon his third count 1 would be dismissed. That's the court's full understanding.
That's correct, Your Honor.
yes, Your Honor.
May I have it sworn?
Right here. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
That's correct.
State your name, please.
Carlos Mack. Sir, it is this court's understanding that you're going to plead guilty to the charge of no valid operator's license on person. That's a misdemeanor, punishable by up to 90 days of jail, $100 fine plus court costs. Do you understand that? Sir. Still wish to plead guilty?
Yes,
And to that charge, how do you plead?
guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
That is correct, sir.
Signed an advice of rights form, is that correct?
One of these, you signed one of these before.
Yes,
All right, any question regarding any of those rights?
no, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are a part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
That's correct.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
I am.
Okay, were you on probation at this time
I am right now.
of this?
Oh, no, no, sir. No, sir.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce?
No, sir.
Doing this voluntarily
That is correct.
and of your own free will,
That is correct.
and because you believe that you are indeed guilty?
That is correct.
On October 18, 2024, at the location of West Michigan Avenue near Clover Lane Drive, in Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
That is correct.
Were you pulled over by the police?
That is correct.
And did they ask you for a driver's license?
That is correct.
And were you unable to give them a valid license?
That is correct.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right. Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything either of you want to say before I impose sentence?
Nothing from the people.
He's made some recent payments. He's trying to get his license, Your Honor.
Sentence of the court, $250 fines and court costs. I'll suspend 90 days in jail. When do you think you can get that paid, sir?
The 250.
90 days?
Yeah, give me that. Can I get 90 days?
Jail?
No, not, no, sir. No.
I didn't know what.
No,
I just asked you.
no.
Sure, and I said, and then
No, sir.
asking me for 90 days.
No, sir.
90 days to pay.
Had no reaction until I said that. Cool as a cucumber. I said that. Oh, no.
Got pickled on that one.
June 30th, 2026.
I have a quick question, Honor.
Yes, sir.
Because I was trying to pay for my reinstate my renewal like today or tomorrow for my license. I got to pay that fine on top of that before that.
We're trying to pay what?
For my license, my reinstatement renewal.
We're trying to pay the reinstatement.
The 125?
Yeah.
The 125. But the 125 would be paid at the Secretary of State.
Right. No, correct. That's what I'm saying. Because now I got this fine on top of that. So I have to pay the fine first.
Okay, so the way I think it works is you can pay that 125 at the Secretary of State, but then don't not pay this because you're going to you'll get a suspension will happen.
Right. What I was saying, because I made a payment yesterday, but I couldn't pay my reinstatement renewal because I had an older ticket that I had to pay on.
Was it this ticket?
Yeah.
I think.
That's what I was like. This way. Oh, it's it's better than you. Yeah.
Yeah. Sir, it seems to me that you got a suspension from a ticket from 2023. This court.
Is that 241-1404?
The ticket number. It looks like it's a suspension from an operating while intoxicated. Our ticket number is 231-0445.
Yeah, that's what I was paying.
Yeah, you pay.
And then you have another one.
Yeah, that's a full case for them.
Well, that's off of the same one.
Yeah.
So it looks to me like there was a suspension, but you may have done something and then you were suspended to April 2nd of 2026, which may be why you're able to potentially pay your reinstatement fee. You then have a ticket out of 14B.
You're on street, on Whitaker.
Never mind, because your suspension was ended in 16. It might, well, that's older, so it might be this one. They did it, but there's an adjudication at least on it. Okay. So, I don't know what the Secretary of State will say. You can tell them you pled to a no ops. Okay. And see if they'll let you pay it. Okay. Got time to pay this one. Okay. All right. So, all right.
All right.
Thank you. Court calls case People versus Nicholas Meath.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Nicholas Meath.
Nicholas Meath.
Move to dismiss the charges.
People being unable to dismiss, that's what that brings.
Thank you. Thank you.
Court calls case People versus Robert Lee Redding.
Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Robert Lee Redding.
Your name, sir? I'm also Robert Redding.
Your Honor, this time the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed.
Thank you.
Without prejudice.
Thank you.
Court calls case of the People versus Jeremy Rice.
Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Jeremy Wright.
His name? Jeremy Rice.
Your Honor, the people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is without prejudice.
Thank you.
Court calls case People versus Nevaeh Smith.
Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Smith, Your Honor.
Good morning, Nevaeh Smith.
Your Honor, people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you.
Thank you.
Great, thank you. Court calls case People versus Ryan Studeville.
Morning, Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Studeville. Can I check the hall?
I guess, yes. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash surety. Warrant will issue immediately. Court calls the case People versus Michael Taylor.
Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of Mr. Taylor.
Good morning. Your name? Michael Taylor. Thank you.
Your Honor, people are unable to proceed.
Move to dismiss.
For being unable to proceed, this case is dismissed. That is without prejudice.
Thank you. Yeah.
Court calls the
Get
case.
his bond refunded now?
What, he wants his money back?
Just like this?
Yeah.
He can't have no money.
He wants his money back?
Yeah.
How much you pay?
I got bills. Take your receipt and your ID to the county.
Okay. They'll see that it's dismissed. They should be able to return your bond.
Do I need to present a receipt
If you got.
when they look it up?
You have an ID?
Yes.
They may be able to do it with the ID.
Okay, thank you, John.
All right, thank you.
Thank you.
You're welcome.
Court calls the case People versus Cortez Triblet.
Your Honor. Raymond Cook for the people.
Ron Brown appearing on behalf of.
Morning, your name?
Chad Triplett.
Your Honor, people are unable to proceed.
Move to dismiss, Your Honor.
People being unable to proceed, this case is dismissed. That is without prejudice. Okay, thank you. But does he want his mind?
Glancing up the clock, I see we're approaching the noon hour over on the East Coast. So let's check in with Judge Hangry and see how that's going.
Monitor, level 3 house arrest. I'm giving him a curfew, 11 p.m. to 6 a.m. Good day, sir. Dollar count 2. Now we have Brett Young, page 10. Good morning, sir. You were arrested for retail theft with a prior conviction. I will appoint the public defender's office for you. There's probable cause for retail theft. Sir, you are ordered to stay away from the Best Buy store at 21035 Biscayne Boulevard in Aventura, Florida. You are not allowed to go to that store and you must stay away from there, sir.
Yes.
Yes, priors. Mr. Blakefield, do you have any Broward County?
I'm sorry, Judge.
Do you have any recent priors out of Broward County?
I'm checking now. He does have a bunch of stuff going on in his NCIC, so this is going to take me a minute to look.
Okay, $2,500 bond, stay away from the Best Buy. Good day.
Judge, would you consider tax?
No. Lazaro Battle Perez, page 11.
Spanish, please.
Good morning, sir. You were arrested for trafficking in cocaine and trafficking in amphetamines. You need Spanish?
Buenos días, señor. Fue arrestado por traficar con cocaína y anfetaminas.
Sir, can you afford to hire a private lawyer?
Señor, ¿se puede pagar un abogado particular?
No.
No.
You own your home?
¿Es propietario de su casa?
Okay, I will appoint the defender's office for you.
Entonces voy a nombrar a la Defensoría Pública para que lo represente.
So I just, I'm sorry.
Looks like they did 2 buys and then a warrant. In this case is the warrant, not the buys.
Oh, okay. And they found, and he lives near 900 feet away from an elementary school.
The buys are with Mr. Perez Martinez.
Oh, okay.
Oh, there's a co-defendant. That's right.
Yeah.
Señor, están revisando la orden del arresto.
So it doesn't state in the arrest form what bedroom Mr. Battle Perez lived in.
It says his mail was found in the same bedroom as the cocaine and methamphetamine. There's probable cause for the charges.
La juez dice que hay motivos fundados para los cargos.
Count 1 is $15,000. Count 2 is $15,000.
Cargo número 1 son $15,000 y el cargo número 2 son $15,000.
Judge, is it with the nebia?
No
Eh,
Nebby,
él-
he found out.
Se le pregunta si hace falta, se podría poner una nevia y la juez dice que no.
Have a nice day.
Que tenga buen día, señor.
James Givens, page 11. Good morning, Mr. Givens. You are arrested for 3 counts of failing to register as required by law. I will appoint the public defender's office for you. There's probable cause for the charges, $2,500 bond each count. Have a good day. Next, John Del Duca, page 12.
He has the whole immigration.
Okay. Good morning.
Spanish, please.
Good morning, sir. You were arrested for possession with intent to sell a controlled substance and trafficking in ecstasy, or I'm sorry, trafficking in MDMA or ecstasy.
Buenos días, señor. Se fue arrestado por tenencia con intención de vender una sustancia regulada y por traficar con éxtasis MDMA.
You also have an immigration hold.
También tiene una retención de inmigración.
I will appoint the public defender's office for you.
Voy a nombrar a la Defensoría Pública para que lo represente.
I'll find probable cause for the charges.
Halló que hay motivos fundados para los cargos.
I don't know about the trafficking. I didn't see a weight. State, you
Eh,
want to call any officer, please, or no?
Sure.
Van a llamar a la gente porque la defensa dice que ya no está segura de que haya motivos fundados en el cargo de tráfico.
I want me to just find possession with intent to sell and possession. It doesn't matter. He has an immigration hold anyway.
I'm fine with that, Judge.
You okay with that, Ms. Corey?
That's fine, Judge.
All right, so count 1, there's probable cause for possession. But
El cargo número 1, hay motivos fundados para por tenencia.
count 1, possession with intent to sell a controlled substance, MDMA, is $5,000. Count 2, possession of MDMA is $2,500.
El cargo número 2, que es el tráfico, la tenencia de éxtasis MDMA son $25,000. Excuse me, Your Honor, I need a repetition. I'm sorry, of the bonds.
Count 1, possession with intent to sell MDMA is $5,000. Count 2, possession of MDMA is $2,500.
Thank you. Las fianzas son las siguientes. En el cargo número 1, que es tenencia con intención de vender, son $5,000. El cargo número 2 es tenencia de éxtasis o MDMA, son $2,500.
Okay, next we have Christopher De Silva, page 12. 1 minute. Good morning, sir. You were arrested for one count of aggravated battery on a law enforcement officer, 2 counts of battery on a law enforcement officer, 1 count of resisting an officer with violence and disorderly intoxication. I will appoint the public defender's office for you. Let me review. I guess the aggravated battery is for striking the officer with a black table.
Yeah.
Judge,
Okay, I'm sorry.
This is dropped in front of a club and just goes after these officers.
no, Judge, it looks like, if you look further down in the arrest form, it looks like somebody pepper sprayed him before the officers even arrived. So if somebody pepper sprayed him, then he probably couldn't see or know what was going on around him if he had pepper spray all over his face. So they don't know that, it looks like, until afterwards that he gotten pepper sprayed. So it's a very unusual set of circumstances. Mr. De Silva's never been arrested before, Judge.
So
He does work for the Postal Service.
You're ordered to stay away from the taboo. Stay away from the taboo lounge or bar, whatever that is. All right. It's a club. Stay away from the taboo club. You want me to find probable cause for just the battery?
Yes, please.
So count 1, I'll find no probable cause. Release outright. Count 2 will be $2,500, 3 $2,500, and 4 is $1,000. 5 is $150. He has money for a bond? Okay.
He thinks so, Judge.
Yeah, I could get it today.
Good luck to you, sir.
Count 5 is 150.
150.
Count 4 is 1,000.
Yeah. If the total bond is $6,150, $6,150. Next, Kamari Ford, page 12. Good morning, Mr. Ford. You were arrested for carrying a concealed firearm, possession of a weapon while committing an offense, fleeing and eluding a police officer, wearing a mask on the street, and resisting an officer without violence. I will appoint the public defender's office for you. So he's on a scooter going against the traffic, almost caused an accident. He's wearing a mask covering his face, trying to conceal his identity. Then they try and stop him. He takes flight on the scooter. He also dropped a black firearm from his waistband as he stopped on his scooter and then took off running. He's 18. He shouldn't be carrying a concealed firearm. I'm setting a bond. Count 1 is $2,500. Count 2, ROR for the possession of a weapon while committing an offense. Count 3, fleeing and eluding a police officer, $2,500. Count 4, wearing a mask on the street, $150. Count 5, resisting without is $500. One house arrest, I'll do that, but I'm not doing anything less than house.
Yes, please.
House arrest, the GPS monitor, there's an alternate box. I'll do level 3 house arrest. And a curfew 11 p.m. to 6 a.m.
Thank you.
Next is Levon Perez Martinez, page 13. Corrections, why do I have to do an order on day if you got a transmittal?
I think it's best because they only put total bond 10,000. It's 2 counts.
Oh, so the total bond for both counts is 10,000.
Yeah.
Okay.
So you.
Hi,
have
Mr.
5,000
Perez.
each,
Hi, can you let somebody let us know so that we can pay your bond on 20?
Spanish, please.
Good morning, Mr. Perez Martinez. You were arrested for trafficking in cocaine, trafficking in methamphetamine.
Buenos días, señor. Ha sido arrestado por traficar cocaína y traficar metanfetamina.
I will appoint the public defender's office for you.
Nombro al abogado de oficio para que lo represente.
There is probable cause for the charges.
Hay motivos fundados para los cargos.
Count 1 will be $15,000. Count 2 is $15,000.
El cargo número 1 son $15,000 de fianza y el cargo número 2 son $15,000 de fianza.
No Nebbia, he can bond out.
No Nevia
No Nebbia, he can bond out.
y puede salir con fianza.
Next, Christopher Martinez.
He
Page
refused.
14.
He refused.
Let me review. So there's probable cause for the charges for Mr. Martinez. He said he refused, so it's reset for the afternoon.
Okay, all in all, she seems to be holding up pretty well. Good for her. Sometimes as we approach the lunch hour in Miami-Dade, we get a little cranky, but doing well today. Let's go back to Texas. Judge Stevens, new contestant.
5CR 1341 is called. The state of Texas versus Jackson.
Yes.
I hope I'm saying that right. You are here, and you are here with your attorney, Miss Lai. Is it Lai or Lai?
Lai.
Lai. And the state's attorney, Mr. Ham. And this is an announcement. As you know, you're charged with the 3rd-degree felony of theft, which carries with it, if convicted, up to 10 years in prison. So it's very serious. Let me ask you, are you still living in Las Vegas?
Yes.
Okay. That makes one of us. 9235?
Yes.
Okay. So what are we going to do today? An announcement. What's our plan? Are we trying to resolve it without a trial?
We've had some discussions, Judge. I've given an offer.
Okay, it's over half a year old. What do we do?
That's
Try and do a conference with the prosecutor.
Ma'am? I'm sorry.
Trying to conferring with the prosecutor.
Okay, what do we do next? What's our next?
Judge, there's co-defendants. The other one is scheduled to make an appearance today. I've asked for them to stay on the same docket. If, probably because of the age and the type of case this is, I would suggest placing it on the 12th.
Again, we go on the trial docket, we go to trial. And that's the way it is. Now, it's a backlog, but we tried, according to the internet, more trials than anyone else has ever tried. So that's what we do, is try cases. If we put it on, we'll just, I don't want it to throw on the trial docket and languish, and then.
If you want to give them one more setting to determine.
Well, it's been a half a year. Everybody's had enough time to figure it out.
I
Which
just
way
made a
you want.
formal offer today. If you want to give them some time to consider.
What is the plan?
I've offered them a cap of 5 years.
Oh, I see.
Does
the defendant have a criminal history?
He does. He's actually on deferred probation out of Harris County. And
Okay, it's deferred. He's not been convicted.
no, sir.
Right? Okay. For what?
The actual
Curious.
charge is tampering with a government record. He ended up pleading. That was the original charge. He ended up pleading and took it as an attempt to commit, resulted in it being a felony 3rd degree. He was placed on 4 years probation. That actually occurred 4 months before this particular offense, and that's the reason why I'm not offering him probation.
Because he was on probation.
Yes, sir.
When this allegedly occurred.
Yes, sir.
So he died 20 votes.
I'm a little fuzzy about something here. I've got this packet of papers here dated March 17th about the defendant's supervision in Harris County, Texas. And I'm not sure, I'm reading this, I'm not sure how, have you read this?
No, sir, I have not.
I'm not sure how to take this. I'm not sure if I'm happy or concerned about what I'm reading here. And it may be just the way it's typed by the person who types, who may not be appreciating the way the wording is used, but everybody gets to read this. That's in the file, and it's concerning monitoring. And it's the way I read this is almost as though Harris County is going to dictate to me how the defendant should be monitored, which is not even close to reality. It's, I don't understand why they would infer that. Maybe I'm reading that wrong, but this court's not going to be bound by anything Harris County does unless this court approves of it. And I don't, maybe that's just the way they write things and it can be read incorrectly, but are there any issues about any type of monitoring that we need on this? Oh.
Judge, I'm looking for the clause number.
What bothers me about it is that the defendant comes into this city, is not from this city, from Las Vegas of all places. And is, according to the allegations in the indictment, attempting to embezzle or steal money in a scheme of deception on the west end of the town here. And there are some things I just don't understand about why someone from Las Vegas decides to come into this city to victimize. That's a bothersome thing. I'm not through, please. And I want to know as much about him so that the people in this city, this county are safe from outsiders who decide that we are ripe for victimization. I don't like that. And we're not talking about a small amount here. This is a third-degree felony theft, which means the value is $30,000 or more. Plus, we've got a Harris County case that is pending where the defendant had a criminal matter dealt with there. Are there any? It's been a half a year. Nothing's moving. I'm going to move one way or the other on this. Are there any conditions that we need to add to the defendant's pre-trial supervision to ensure the safety of the community?
I apologize, Judge. I don't know what the current conditions of his bond are.
I don't either, really. The only thing I know is that there's a $100,000 surety bond here in the file. But
so between the two defendants, this is the only individual that has a record, and I have genuine concerns that this offense is committed while he just started a probation out of Harris County. I do appreciate that they at least ordered a monitor.
What was the,
like you, I
what was
don't
the
like them
offense?
trying to dictate your terms.
Yeah, what was the offense out of Harris County again?
It started out as a second degree tampering with records, but he ended up pleading to a third degree and attempt. And they placed him on 4 years deferred probation.
Can you tell me a little more? What are the records?
I don't know anything about it, Judge. I just know what was reported to me on the NCIC report that we have.
Do you have an indictment from it?
No, sir, I do not. I don't have anything other than a cause number and what the end result was. I'm going to need to reach out to Harris County to find out more information.
You do have a GPS device on you. Is that being monitored out of Harris County or?
Yes. You should see the bond conditions, Judge, that we have the system, you should take his monitoring.
He used to have a GPS from Jefferson County, and then
Yeah, two. He ended up having two of them then, right?
now he only have one because the Harris County cut off the Jefferson County one.
They did what?
They cut off it.
Oh,
Here's the thing, Judge.
yeah. Well,
Since
let
he
me
was
ask you this, why, we're gonna get into this. Did they do it without our permission, without our knowledge? That's kind of rude if that would happen, and that would be very unprofessional, but I don't think that's what happened.
this my
And I can understand you don't need two GPS devices if responsible monitoring is being done by one or the other. But the point is that we don't know what Harris County is doing. They could dismiss their case tomorrow and then the GPS falls off and then we don't have a GPS. What I want to know is to make sure that the defendant is being monitored
yes
at all times. And if there's a change in the monitoring, we have a professional courtesy, just a right to know, since everybody is, Harris County is aware, there's something here in Jefferson County that's pending, and us for Harris County. That's all. Just want to make sure that we're all on the same page, and if there is a change, all parties are to know about it as soon as possible, so that he doesn't fall through the cracks, as it were. That's all. And that's not a lot. That's not anything to ask for. That's only the right thing to do.
Maybe inquire as to his probationary terms, where those are monitored, whether that's here in Harris County or if it's been transferred to the other state.
I don't know. I don't know the answer to that. Does he come to Harris County to report, or is he courtesy supervision in Las Vegas? Do you know? From Harris County, did Harris County transfer it over to Las Vegas for Las Vegas people to monitor? Or does he have to come into Harris County every month? I don't think that would be logical, right?
Yeah. I think he was monitored by his probation was transferred to Las Vegas.
Okay.
Yes, yes.
I mean, courtesy supervision, that's normal. Okay. So they're the ones, Las Vegas monitors. The only issue is that the monitoring from Jefferson County needs to be aware that if there's an issue, they and Las Vegas monitoring need to communicate and have open lines of communication, so that if there's a change in the status in any way, we don't find out about it a year later. We find out immediately, since Jefferson County. And I'm going to ask you if you'd be so kind, ma'am, to make sure that is done, because I can say, I'm not going to let him be curt. I'm going to do it now, but as long as we stay in communication. If we don't, then he's going to have to come into Jefferson County every month to report, which I'd rather not do. But I have, but we're not aware of where the consistency and the communication lines are connecting with each other. Everyone needs to be in the same, on the loop, please. And we need to get this accomplished immediately, so that there's not a lapse in our supervision. Because if something happens, if he's not following the rules in Las Vegas, how do we know? We have to trust Las Vegas to tell us. And if they're not going to be willing to do that, then he's going to come over here and report every month, which is not practical.
Yes.
That's not what I want to do.
Thank you, Judge.
Let's get it 2 weeks to figure this out, okay? And I just want to know, he didn't have to be here. Everybody needs to know about everybody being on the same page.
The Harris County probation is 4 years probation, so they're not gonna dismiss the case in a short time.
Understand?
Yeah. So he will
Understand, but I just don't want,
Yes.
I just want Jefferson County to make sure that we know if something happens in Las Vegas, we don't find out about it a year later. We need to know immediately if it affects our supervision over him. And what do you want to do on your next event? What's the next event? Do we put it on the trial docket, or do you want a few more weeks to try to figure this out? It's your call. Because it's a half a year old, but I can give you some more time.
How about reset one more time?
Okay.
Yeah.
How much time?
1 or 2 months, please.
How about, is 5 weeks good?
Yeah.
Okay.
That works good.
Okay, we'll reset 5 weeks. Thank you for announcement.
Thank you.
Okay. Gregorio Flores.
You just know.
Good morning, Judge.
Judge, I'm looking at this file and this was assigned to somebody else previous, who's no longer with us. And the first amended motion to revoke probation, which is alleged in this January 28, 26 administrative hearing has not been filed yet. So we can either deal with it without filing it, or I'll get it taken care of before I.
What's the master plan?
So Mr. Flores blew a 0.068 into his interlock and he didn't submit to a follow-up test. So it's unable to determine if he was using alcohol, if he drank alcohol or if it was an alcohol contaminant. I'm recommending that he obtain a scram device in lieu of the interlock, so it's going to be continuous monitoring of his alcohol consumption at any.
Okay, so when we do a 068, what's the normal protocol? What are they required to do as mandated by their terms of
He
release?
would have needed to submit to a follow-up test because if it was alcohol, it would have stayed.
Okay, and they know that.
Yes.
Why didn't
It was my first time.
Well, but I hadn't, I mean, are they told?
Yes, Mr. Flores should have known.
How should he have known?
I addressed it with him and.
Oh, you did.
Well, when I mentioned it, that I was going to be filing this first amended, he said that he admitted to knowing that he should have submitted to the follow-up test.
Why didn't you do it?
I didn't do it at the moment. I was, it just turned off. I just turned it off and I didn't turn it back on.
Why didn't
I didn't react it because I've been having the interlock for over 2 years. I've been having it for 2 years exactly. So it's just, the first hit, I didn't think nothing of it and I got complacency and there's no excuses of what I did or what I didn't do, but I'm just.
Well, it doesn't make any sense. It's just, you made a choice not to follow the rule.
No, sir.
You didn't know you were supposed to have a follow-up? He says you were told.
Of the test itself?
Yeah. Yeah, 068. There's supposed to be a follow-up.
Yes, sir.
But he knew that.
Yes, sir.
When was he told that if that happens, he has to have a follow-up? Who tells them that? Because I don't know practically how that works. I just know there were requirements. I just don't know how they're conveyed to the defendant.
He should have been notified whenever he did the interlock.
Ma'am? Oh, well, who would have done that?
You have it through Smart Start.
Smart Start. Yes.
Well, they didn't tell you?
Honest to truth, Your Honor, I just didn't think of nothing of it. To be honest with you, I didn't react towards it, All I said when I blew was said warning, and I was just,
Is this just being held open by the MTRP or when does his expire?
27th. February of 27. It was extended 2 years to align with the DWI he got.
Well, thing is the conditions of probation that he signs and he was aware of and that are ordered, when it comes to alcohol, it states don't become intoxicated. Doesn't say don't use any alcohol. So how does he know at a 0.68 if it's not deemed intoxication that he has to do a follow-up? Where's that ordered?
It's part of the conditions of the interlock. So
Where are those conditions of interlock? I don't have them. I never have seen such a
not
thing.
necessarily conditions, but the instructions. So
Well, I've never seen such. I don't know.
This is how to-
This is what he gets. And everybody else gets.
no, sir, but that's how to read the report. So it says that without a follow-up test, you can't determine if it was alcohol or an alcohol contaminant.
And where he's, I mean, for his fact situation, where does I think that fall in the list of things? If it's a 0.068, where in that document, where would a person on probation go, uh-oh, this says I've got to do this next? I'm not talking to you. I'm talking to her. And so that there's, I mean, we got an issue here, and if it's a gap that we need to fill in, you know, we always see a unique set of circumstances.
I think the first issue
What was his requirement when it's a 0.68 of anybody?
To submit to a follow-up test.
Where does it say that?
He would need to submit to the follow-up test that day to operate his vehicle.
He did the 6 hours later though, didn't he?
6 hours later.
6 hours later, he did it.
The vehicle is frozen for 6 hours. Is that right? Is that what happened?
Yes.
Well, so what'd you do? Just sit around or
No. I just, no.
waited for a few hours later and come back and started?
No, sir. To be honest with you.
Yeah, that'd be a good thing.
Whenever you blow, it basically just states warning, puts a warning as it.
Well, she says that it freezes, you can't start your car for 6 hours. Is that right?
No, wouldn't be able to start the car until he blows again without any alcohol in the breath. He would need to blow a 0 before he could start the car.
But that's the point, though. The car, it was frozen, right? You couldn't start it immediately.
No, sir.
So what did you do?
To be honest with you, Your Honor.
Yeah, be honest with me. Yeah, what happened?
I just kept on living my day the way that.
And then went back to the car later to start it?
Yes, sir.
Like 6 hours later or something?
Yes, sir.
Okay, so you were at home?
Yes, sir.
I see that.
Okay.
Well, I show it was held in advance and that we were setting it up for review. It's still.
Figure out how that practically works.
But Judge, here's the problem I have. I agree that there's a violation here, but this man was placed on probation in February of 2025 for 10 years. And we're past that 10 years.
You said that that was
2015, sorry, 2015 for 10 years. And we're past that.
Was there a motion filed?
And there was a motion filed and it's held in advance, but you still.
As it was extended 2 years.
Yes, but I cannot file a motion once even if it's held in advance because that original probation has expired. It doesn't hold it open for all the violations, I don't believe, according to the law. Now, he did violate his probation that he's on a misdemeanor that he got in 2025, I believe, for 2 years, that he still got a violation on. He's got to deal with down the hall. But I'm not sure that what we can do with this.
Was it ever actually extended? I mean, I know it's been held in advance the whole time. But I don't see it on the portal. I don't see it actively.
13/15.
I didn't see one in here. I was looking. It just says it's interpreted held in advance back on May 14th to 25. June 15th says held in advance review.
I guess there could have been a hold on him.
Yeah, but I don't know if you can extend it for 2 years on a 10-year probation on the deferred for injury. You can with like financial stuff. Sure. You go past 10.
I used to think you could, and I think that I learned you could.
Well, see, it just, as long as a motion is filed before the 10 years, that tolls things.
It tolls giving him a sentence, but I don't think we can't amend after it's expired or would have expired. We cannot amend a motion to revoke. We've been through this. Yeah, we've been through this
So who's amending the motion to revoke?
Well, we've asked for a first amended, otherwise we don't have anything really. We got to the administrative hearing here.
I guess you can, I don't know if you can do it for administrative violations or not. Not sure. That's my problem I have is.
I'm not sure this is the right time. We're gonna stop and do research.
Yes, sir.
Could everybody look into it?
Yes, sir. We can have just a week or two to kind of look at it.
Yeah. You live in Grove?
Yes.
Oh, okay, you're local. No, I don't. I'm gonna come back next week. Can y'all look into it, Michael?
Yes, sir.
Mr. Laird, can y'all look into it and come back next Wednesday
Yes, sir.
and see what we
Next
do?
Wednesday?
Yeah, it's Wednesday. Thanks. Because I want to know. I mean, if he doesn't need to be on probation any longer, that's another thing.
Yes, sir.
We don't need people on probation longer than necessary. My theory. Okay.
All right, friends, let's pay one last visit to Judge Simpson before we most likely head off to Dungeon Court. Or not. At least once a week, as soon as I go to some feed, it's removed. I don't have Dungeon Court queued up yet, so let's do this. Let's go to Judge Anzalone for a few minutes.
Thank you so much. We are back on the record in the matter of the people of the state of Michigan versus James Albert Hall, file number 25-22428FH. Mr. Murphy also did advise Mr. Hall that any plea agreement or sentencing agreement could be negated by this potential violation of bond conditions. So, Mr. Murphy, how does Mr. Hall wish to proceed?
Your Honor, could we just enter a not guilty plea right now in regards to the violation? I thought that there was going to be new charges stemming from the arrest. I guess that'd be yesterday or the day before, Mr. Hall. I'm not sure though, but what I was going to ask for is that we set this. I don't know if the Your Honor was going to continue with sentencing on May 1st or not, but I'd ask if you could just set this for the date of sentencing. And I guess, you know, in regards to Mr. Hall, he was in
Mr. Murphy, Mr. Murphy, let me interrupt you real quick. The jail list does show that he's being arraigned or has been arraigned on a disorderly person. So it says 9:30 this morning, but I suspect they have not done that yet, but it does appear he has pending disorderly charges. I don't know, that's what he was arrested on. Whether or not those are the actual charges against him, I don't know.
I've watched the body cam of his arrest, so that's why I anticipated that probably, because I think that's what they were arresting him for, and found out that he had bond conditions and things like that. So, Your Honor, Mr. Hall was in the Haven. I guess there was some, you know, he was in treatment. There was some violation of their rules, and they asked him to leave, which then sparked this incident, I guess. So Mr. Hall he desperately wants to go back into treatment. So I was asking the court to consider, well, you know, we do have sentencing coming up. If you consider allowing him to be screened and released to a rehab facility instead of just having him stay incarcerated. Or again, I know there's some issues in regards to how the actual process occurs, because I don't know if Your Honor wanted to keep him in the jail until sentencing was done or not. But I think that in regards to Mr. Hall, getting him into treatment is the best thing as soon as we can do that for him. Of course, if Your Honor disagrees with me, then obviously that's
Okay, so I will enter a plea of not guilty on behalf of Mr. Hall. I will continue, I will obviously revoke his bond. I'll set bond in the amount of $25,000 cash. I will, and that's both on the violation of bond condition and the underlying file. Obviously, we can have Mr. Coast assess him for perhaps inpatient treatment, but I am going to keep the sentencing date on because his pending charge is probably a misdemeanor. I don't know that it really impacts his sentencing on the felony. So we will see you back for sentencing on May 1. Mr. Hall, do you want to be brought over in person for sentencing or do you want to appear via Zoom?
I had a bunch of stuff that I was gonna show you and I don't have that now. I'm not
My
prepared.
question, okay, so Mr. Hall, do you want to be brought over in person for sentencing or do you want to appear via Zoom?
I'll do it in person.
Okay,
I'll do it.
so we will make sure your sentencing is in person and have you brought over. And we'll see you back on that day. I'll set the contempt court over to that day as well, Mr. Murphy.
Thank you, Your Honor.
Thank you. All right, thank you.
Thank you. Have a good day. Mr. Hall, I'll talk to you soon, okay, as soon as I can. All right.
Okay, friends, we've reached that time on a Friday where we do a fun thing. If you're new to the channel, this is our guilty pleasure. It is a court where the screams of the dead and the sentence can be heard in the background. The Soviet-era lighting kind of grabs your attention and adds to the ambiance. The carpet, shining crimson, beautiful stuff. A grumpy judge, the crypt keeper who seems to walk the side of the courtroom for the prosecution. You can just almost smell the mold and mildew. In Appalachia, justice is best served in a cold, dank basement. Ladies and gentlemen, I give you Dungeon Court.
I've been on home confinement.
Okay. Where are you out on?
Cabell County.
So you just had a fine court cost, you weren't ordered to do community service, which usually is the case, you usually have community service. Were you in the drug court or what?
I completed 3 separate programs during the time that I've been on home confinement, so.
You got some paperwork on that?
Yeah, right here.
Who was your judge?
My judge, I think Ferguson. I know that they completed that case, so I'm just finishing out my home confinement. They put me on home confinement for 2 years, and I complete in October.
Okay. What I'll do, I'll cancel the warrant then, since you came in. I'll set you up on a new review hearing.
Okay.
And then you have to come back till you get things finished. I don't need copies.
Okay.
You only owe $175. You get $100 tomorrow if you come out and work community service. You get.
I would love to do that. Would I be able to be done by 3? Because I go to work at 3.
You should be finished by 3.
Okay. And I come in at 9?
7:30.
7:30. Gotcha.
Yeah, 7:30.
I'll be there.
On the west side of the building.
Okay.
Show up there. Okay, let's see. Are you working now or what's?
Yes, I currently work at a recovery center in Ohio, in Proctorville.
What's your work schedule?
It's kind of, it's always changing,
So you can come Monday or Friday?
Yeah.
That's when we have courts.
Yeah, I can make it work.
Monday or Friday. So I'm going to set it for the 18th of May. That's a Monday.
Okay, that sounds good.
May 18th will be your next review hearing. If you come to work tomorrow, you're only going to have $75 left. If you get it all done by the 18th, you don't have to come back because that's all you have is fine court costs. You don't have anything else.
Okay.
You understand what you need to do?
Yeah, if I come in tomorrow, then everything will be good, right?
Well, no. You'll still owe $75.
75,
You
right.
get credit for $100, you owe $175, so that's going to come off, you still owe $75. So you can either work some more community service to work it off, or you can pay $75, or a combination of the two. But you gotta take care of the $175.
Gotcha.
You'll put a big dent in it if you come out tomorrow.
Yeah, I will probably do that.
Okay. Next hearing, May 18th, you wanna write that down? There's a form right here in the basket for the date. May the 18th, 9 a.m. tomorrow for community service, will be here at 7:30.
Okay. All right.
State of Ohio, Jenna Jacobs, case number TRD 26570 A and B. Jenna Jacobs.
Jenna Jacobs was excited to be here today at 9 a.m. She's traveled to appear. This is an OSP citation. Oh, she is here. Okay. Ma'am, you're Jenna Jacobs?
Yes.
The state's alleging that on April the 8th at 9:13 p.m. in Fayette Township, you were driving a vehicle under a suspended license. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine, and that you were using a prohibited electronic device. Cell phone. I was reading the report. It says alleging you were using your cell phone while driving. So that's a minor misdemeanor, maximum penalty is $150 fine. Do you understand the two charges?
Yes.
Do you understand your rights as a defendant?
Yes.
How do you plead?
Guilty.
Guilty means you're admitting it's true and you're waiving the right to have a trial and have a lawyer by doing that. Do you understand that? Yes?
Yes.
Okay, the officer says, US 52 at the intersection of County Road 410, driver was using a cell phone while driving. Driver is suspended. She stated that she was on FaceTime. That's even worse. You're FaceTiming while driving. Cell phone was observed to be in contact with her person as she was driving down the road. She was confirmed to be suspended out of West Virginia. Why do you have a suspended driver's license?
For driving with no insurance.
Well, he said you didn't have insurance. Now, in Ohio, that's not a criminal offense, but I guess in West Virginia, maybe it is. He said you didn't have proof of insurance on you either. Is that right?
Yes.
Okay. Well, can you get your license in West Virginia reinstated?
Yes.
Because here's what I typically do. If you can't get it reinstated, I'm going to give you a jail time that's suspended if you do community service. But if you get reinstated, I'll just give you a fine. I won't give you any suspended jail time or community service. Now, here's the question. What do you need to do to get reinstated?
Get insurance. I have insurance, and an SR22. I just have to go to the DMV.
Okay. Are you still living in Charleston?
No.
Where do you live now?
Canova, West Virginia.
Okay. You're still in West Virginia though. Well, do you want to come back then and show me that you got reinstated? Then I won't give you any jail time or community service.
Yeah.
How much time do you think it's going to take you to get that done?
Monday.
You can get it done Monday? Well, sometimes things take longer than you think, so let's go further out than that. I'm thinking a month. How about a month to give you? Now, don't wait until 29 days and then start working on it. I mean, I won't give you time, but I want you to start working on it now. And I guess you know where the DMV is on Madison Avenue, right?
Yes.
Okay, you know where it is. You need to go there and talk to those folks and get it taken care of. Do you work?
No.
Okay, so you can come Mondays or Fridays. Let's make it a Monday then, because usually they're not as busy. May the 11th is a Monday. I'm going to set that as your next hearing. I'm going to accept your plea, but I'm going to delay the sentencing until May the 11th. I'm not going to make you go, I'm supposed to make you go get fingerprinted, but for this, I'm not going to make you go get fingerprinted. And then there's going to be a sentencing hearing at 10 o'clock, but I will have you sign a $500 signature bond. So what that means is you're just signing a piece of paper that says, I promise I'll be in court when I'm ordered to, or I'll pay a $500 penalty, and you get a warrant issued too for not showing up. So just come to court, you won't have to post any money. Do you have any questions about what you need to do? Okay, get reinstated. If you don't get reinstated, still come back and tell me what happened and ask for more time. Just don't blow it off, because then I gotta issue a warrant for you.
Okay.
Okay, May the 11th, you write that down?
Yeah, I got it.
You got it? May the 11th, 10 o'clock, your next hearing. Free to go.
State of Ohio versus Charles Lee Smith, case number CRA 26152. So CRA, there's CRB, so I'm not sure.
It is a CRA case number.
This is for the 24th. I can't be here that day, so
And you are Charles Lee Smith?
Yes, sir.
Mr. Smith, you're charged that on March the 6th of this year in Fayette Township, you not only obtained, possessed, or used a controlled substance being cocaine, possession of which is a felony offense.
Yes.
Maximum penalty for that's a year in jail, $2,500 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
You had to make a hire lawyer?
No,
You have a job?
I do. I'm working part-time. I cut hair for a living.
Oh, okay.
Yeah.
You're working part-time?
Yeah, a couple days a week right now.
What do you make an average week?
$100, $102, $100, maybe $200
Okay.
on my check.
You're eligible for court-appointed counsel. I'll appoint Mr. Smith to represent you.
Okay,
He's right behind you.
all right.
State's position on bond, and I've got an address of Ironton for you. Is that right? County
Yes.
Road 119 Ironton?
Yes, sir.
Your Honor, I want to make sure that we know some details here. We have a case right now already pending with Charles Smith that is set for hearing on April the 20th.
In this court?
Yes, so I don't know whether this is the same gentleman or a different, this is.
That's pretty common. That's pretty non-common.
Yeah.
Yeah, he says it's not,
Okay. I just want to make sure.
That's not me.
What's the state's position on bond?
We're okay with an OR bond if Mr. Smith's willing to be assessed for treatment.
he is an Ohio medical board judge, that's acceptable.
Okay. Who we got, the offices in Ironton? Bethesda, okay. I'm going to refer, are you okay with going to a faith-based program?
Yes.
Okay, I'm going to refer you to Bethesda, it's a faith-based program. And here's, I'll give you the thumbnail sketch, and you can talk to your lawyer about it more. But you're charged with a felony.
Yes.
Now, what felonies mean, it used to mean a lot worse, but in the old days, they were all capital offenses. A felony is a capital offense. Now it means you can go to prison if you get convicted of a felony. That's the dividing line. Misdemeanors, county jail. Felonies, you can go to prison. You're charged with a felony. You start out in this court, but if it's not some intervention, you're going to go on to the main courthouse in Ironton for the common police court. They're the trial court for felonies. And felonies are considered so serious that your fellow citizens have got to look at they don't even trust the prosecutor just to bring them on their own. You got to be indicted by the grand jury. That's what a grand jury indictment is. Your fellow citizens look at the evidence and say, yeah, that guy should be charged. So what's going to happen here, or could happen, it's up to you, you're going to go to treatment. You're going to stay here. You're not going to go to the grand jury. You're not going to get indicted. You're going to stay here, go to treatment. If you do really well, the best outcome is way down the road, your case gets dismissed. You don't get a felony on your record. You don't go to the grand jury. You don't go to Ironton. Although you live in Ironton, maybe don't mind going to Ironton, but you don't have to go to Ironton to the courthouse.
Yeah. Yes.
Okay, so
I
is that what you want to do?
Yeah.
So I tell people, this is a court for people that want to get clean. If you want to get clean, get in recovery, I'm all for helping you. If you don't want to, go down there and fight it out with one of the common police judges. Take your chances. you want to stay here and get clean?
Yeah, I've been clean for a year. I had a relapse. Yeah.
Okay.
So,
Well, part of it is being honest.
yeah.
First
So,
step is admitting you made a mistake.
yeah, I made a mistake and so let's move
Okay,
forward.
so I want you to talk to the representative from Bethesda, get something set up for enforcement, get in there to see them. And then what's gonna happen is you'll come back to me periodically and I'm gonna review what you're doing.
Okay.
So and a lot of times, they'll text me like in the middle of the day or in the middle of the weekend. I've had people pulled out in the middle of the weekend and sent to jail because of the way they were acting during treatment, so.
Right.
Don't be one of those people.
No.
Okay, so Bethesda. Next hearing, let's do, what's your bad, I know you got some bad dates in
I
mind.
do, in May, 4, 8, 15, 27 are bad.
Okay, it's getting crowded, let's do the first then.
I can do that, Judge. May 1st, I'll check that down.
May 1st will be your next hearing,
Is that on a Monday?
Friday.
Friday? Okay.
Better for you Friday.
Your bond is going to be,
He says
he
Monday,
already has a bond?
could he do a Monday? He says Mondays are better for his schedule.
Okay. Okay. Okay, I'll set it for the 8th then.
That's one of the bad, I'm sorry.
That's one of the
The
bad.
8th, 15th, and 27th in May are bad.
Okay, the 24th then, of April.
That's a bad April. There's no more lawyers left, Judge. I've got jury trials every week, it
How
seems.
about the 27th, April?
That starts another jury trial.
20th,
Yes,
April 20th.
yes.
So 10 days, we'll be back to give the first report on how you're doing.
Okay.
You need to get an assessment today. He can sign 2,000 OR bond.
You already told me about the bond.
You did?
Yeah.
It has made.
Yeah, I'm through salads,
How much was your bond?
2,500.
All right, I'll take your word for it and continue. You can have him sign out 2,000 OR anyhow, but I'll continue with salaries and we got on top of it.
Monday, I'm saying, get that plan set up.
It's not in the file, but it was
There's a
at
place on the back,
jail.
so they'll give you time, you can write it on the back.
Did they fingerprint you to jail?
They did. Yes, sir.
But there's one, you next day, that's for you to call Sam at the office. Well, he'll give you a day.
Okay.
So just call him Monday.
Okay, thank you.
You're good, yes, sir.
State of Ohio versus Vicky Scarberry, case number TRC 24-1272, A and B. Vicky Scarberry.
Okay, and Ms. Scarberry, looks like you had a review on Monday
Yeah,
and you weren't here.
yeah, I didn't come.
Okay, do you have an explanation?
I was working, but I also didn't have any of my community service done, so I thought it'd be better to come Friday.
Well, have you done some community service since
Yeah,
this week? Where'd you do it?
the animal shelter.
Okay.
I've been doing the outpatient program on Route 60, so they've dropped down my days, so that's why I was able to go start it.
That is correct, Your Honor. She has turned in 7.5 hours of some days.
Okay.
It will be acceptable.
You finished it, Presbyterian, right?
Yeah, I completed a long-term inpatient for women and children there. And I'm still, in the program, like the outpatient. No, it's a 3-month program, like, so I completed that and I'll drop down to just the, like, 1 day a week, the MAT program.
Okay. You still have your community service to do and most of your fine, right?
I paid $550 on it today. I have my receipt.
Here at the court?
Yeah, it was before court.
Okay.
She said I could go ahead and pay
Oh,
on
I
it.
see it, you know, they didn't know you in the file. Okay, that was a big chunk of it. All right, I'll set your next hearing for May the 15th. May 15th is your next hearing, 9 o'clock.
Okay, thank
Cancel
you.
the warrant that had, well, I don't think it actually got issued.
It would have been Monday, I would have had a warrant.
Okay.
Okay,
Get your
thank
community
you.
service done too.
Okay.
Get double credit tomorrow.
Okay.
Get 2 days credit for one, come out tomorrow, 7:30 a.m. right here.
7:30. Okay, thank you.
You're welcome.
State of Ohio versus Alice Smith, case number TRD 29385 and CRB 2452.
And it looks like, Mr. Smith said, Sean, you started there, right?
Yes, sir.
You had a couple cases here that you had not completed. One was 2452 case number. The theft offense is still owed 20 hours community service, $280 in final court costs, and the other was driving or suspension, 25,385 case number. You had $325 on that. And there had been warrants issued because you failed to appear for prior hearings. So what I'm going to do is I'll withdraw the warrants and put you back on the review docket.
Thank you, Your Honor. Yes, sir. Thank you.
And I'm going to make a part of your orders that you complete treatment. So you decided to do it on your own, but I'm going to make a court order now. So if that helps you stay.
Your Honor, I was told from whoever's running it, Leslie.
So he was admitted for 30 days residential treatment per his request of his employer.
Okay. Well, I'm going to order that you do that now.
Okay.
Okay.
So they're going to keep you if you do this program?
My job?
Yeah.
Yes, Your Honor.
Okay. I'll set your next hearing. May the 18th. So you should be finished by then, right?
Yes, sir.
Okay, May the 18th. So I'd like to have a report from Shawnee when,
Yes,
if
sir.
and when he finishes, or even if he doesn't finish, let me know that too, so. May 18th is the next hearing, 9 o'clock.
Thank you,
sir.
sir.
You're welcome. So there's both of says review.
State of Ohio versus Brittany Zandy, case number CRB 26198 A and B. And State of Ohio versus Zachary Russell, case number CRB 26199.
Andy and Zachary Russell. Mr. Andy, case number 198A, the state's alleging that at Rome Township, April the 6th, you knowingly caused or tried to cause physical harm to Zachary Russell, and that he's either a member of your family or lives in your household. That's a domestic violence charge, maximum penalty 6 months in jail, $1,000 fine. 198B alleges April 6th, Rome Township. You interfered with the lawful arrest of yourself, so that's resisting arrest and a second degree misdemeanor. Maximum penalty is 90 days in jail, $750 fine. Do you understand the two charges? Do you understand the rights you have as a defendant?
Yes.
How do you plead to these charges?
Not guilty.
You want a lawyer appointed?
Please.
You work?
I am getting a job at the South Point Speedway. I have an interview April 13th.
Okay, but you're not working currently?
No.
I'll appoint Mr. Steyer. Not guilty plea is entered. And there is a bond posted. So, and I take it this is Mr. Russell. Do you want me to order her to stay away from you? It's not a protection order, we don't want a protection order. Okay.
We don't seek one either, Your Honor.
All right. So there is a bond posted, so it's continued as you posted it. So let's go ahead and arrange Mr. Russell, so we make sure we get to these on the same day. You're Zachary Russell, and Mr. Russell, you have a domestic violence charge, 26-199, that's the only charge you have. It's alleged that April 6th, Rome Township, knowingly caused or tried to cause physical harm to Brittany Danby, and this is a member of your family or household. Domestic violence is a first degree misdemeanor, it carries a maximum penalty of 6 months in jail, $1,000 fine. Do you understand that charge? How do you plead to it?
Not guilty.
Do you want a lawyer appointed?
Yes.
Do you work?
Yes.
What do you do?
I collect grease and refine it for biodiesel
Do you do that for yourself or somebody else?
for someone else.
Are you paid a salary or by the hour?
By the hour,
How much per hour?
16,
How many hours a week?
roughly 40.
Do you have any dependents that you support?
Yes.
Tell me about that.
I have 2 children. They're 6 and 7.
Okay, well, you're eligible for court appointed counsel. And I'll appoint Mr. Morford. So not guilty plea is entered. And Ms. Bandy's already said she doesn't want a protection order, so he has a bond up too, so his bond's continued. So now we need to agree on a date to come back. So I'm looking at generally the 4th of May or after, what's council's available dates?
I'm good the 4th, Your Honor, if you want to do this.
Monday or Friday night?
Monday.
Mondays are easier. I'm available the 4th, Your Honor.
Okay, let's set it for other cases for May the 4th, it's a Monday, for pretrial at 10 o'clock. Not guilty plea or enter for both.
Thank you, Your Honor.
You're welcome.
Keep the silent come out. Wait for me in the lobby. I appreciate it.
Okay.
Just give me 2 minutes.
State of Ohio versus Ashley Bailey, case number CRB 26196, PRD 122906.
And you're Ashley Bailey.
Yes, Your Honor, I am. Is this just a copy of, I don't know what, okay, I'm sorry.
All right, Ms. Bailey, the is 26-196, and it's a theft charge. It alleges that on April the 8th, in Fayette Township, Lawrence County, you purposely tried to deprive Walmart of property without their consent. It's a theft offense. Maximum penalty for that, 6 months in jail, $1,000 fine. And then there's an old case, 12-2906. It's alleged it was a driving under suspension conviction that you still have a fine owed. that you failed to appear for review back in, 2015.
I was gonna say, I don't remember that, Your Honor. I apologize. I do have my license now.
The last review hearing date was March 23rd, I'm sorry, that's wrong. December 30th of 2016.
I apologize. May I ask how much I owe? And I won't be able to pay it today, but I will take care of that
$285.
if you will allow me to. And I have regained my driver's license.
Okay.
So $280 for the previous driving on suspension.
$285.
Yes, sir. I should be able to pay that at the end of, by the end of next month. I should have that paid off.
Okay. How do you plead to the theft offense?
I do plead guilty, Your Honor.
A guilty plea is a complete admission that the charge is true, and it waives your rights to have a trial and a lawyer. Do you understand that?
I do, but I am guilty and I did it.
Okay.
Yeah.
Well, here's what I'm going to do, and it's not directed just to you, but I do it in all the shoplifting cases because I found over the years, and I handle a lot of these, that about 80% of the people that shoplift have a drug problem. So I'm going to have to go do a urine screen to see if there's an issue there, and if there is, we're going to address it. So go to the probation office, and I'll direct you how to.
Your Honor, I want to go ahead and tell you, I will be positive for marijuana.
Well, people tell me that, and then they're positive for other things
Well,
too. So.
I'm on anxiety medication, so I do have I don't have any like other only marijuana, and I do have a medical marijuana card as well, and I get my prescriptions from my gynecologist.
Okay.
I can go take a urine screen though, yes.
Yes, because I've had multiple people
That's
tell me I
fine.
only smoke marijuana and they're positive for fentanyl. 'Cause
That's fine, I'll go do
people,
that.
unless you're getting it from a dispensary, you don't know what's in it.
I will go take a urine screen, yes, sir.
Okay. Then you'll come back after you get the results.
Okay.
State of Ohio versus James Helton, case number CRB 26197, A, B, and C, and CRB 23111.
James Helton.
And sir, you're James Helton.
Yes.
Mr. Helton, 26197 alleges that March 27th,
She's doing a drug test.
2026,
Yeah.
that you purposely tried to deprive Lowe's of property without their consent. It's a theft offense, maximum penalty 6 months in jail, $1,000 fine. So that was March 27th, and then there's an identical charge, 197B. The only thing that's different is alleged that it happened on April the 6th, for a theft offense, same possible penalty. The third charge is also a theft, and is a different date, March the 8th. So there's 3 different dates, all shoplifting theft offenses from Lowe's in South Point, Fayette Township. Do you understand these charges?
Yes, I was still trying to get it figured out what that is, because I was confused about it, but yes, I understand.
Do you understand the rights you have as a defendant?
Yes, sir.
How do you plead to these charges?
I'm not guilty.
You want a lawyer appointed?
Yes, please.
Do you have a job?
I just do what work's available. I make usually about 800 a month or so, something like that.
Okay. You
It's
also
not-
have, I didn't tell you about this, it's alleged that you had a theft offense from 2023 that you never finished. You had,
I still owe you fines on that. I brought $30 to pay on that today with me too.
and you posted a bond because of that. You posted
Yes.
a bond. Okay.
Yeah, and I got $30 to
They're
pay
not
on
guilty
that
plea
too.
for you on the new charges. Your bond, you got a bond posted now. If you don't show up now, the bail bondsman's gonna come fetch you and take you
Yeah,
to jail.
yeah, I'll show up.
And then are you not guilty plea? Mr. Morford, you were his attorney before, so I'm gonna appoint you on this new charge as well. Set both the old case and the new case for pretrials. You said you're available anytime, Matt?
Yes, Your Honor.
Sign your name, put your trouble number.
Let's do the 4th then. May the 4th?
good, Judge.
Pre-trials on both. Pre-trial and review on the, there is a bond up, there's a bond, I'll say it's for both. And you can make a payment on your old case.
Yeah, that's what I brought today. I brought 30, but they said to see you first before they let me pay.
You can go see the clerk before you leave, pay on it, tell them you want to pay on your old case.
Okay.
And May the 4th will be your next hearing on both cases, May the 4th at 1 o'clock.
Is that all, Your Honor?
Yes, sir.
Thank you.
Thank you, Your Honor.
Okay, friends, we're going to end the week a little bit differently from what we normally do. I would like to leave with this message that Judge Middleton posted at the close of business yesterday.
All right, we're going to do a little brief sign off here. Thank you all. Hello, Mr. Lone Wolf. I see your channel from time to time. And others who are watching this. This will be the last live stream from this courtroom. We just took the last plea. As I indicated this morning, this courtroom opened about 1976 or 77. I get my days of years mixed up. When I first came here at the county in 1978, everything still smelled like new paint and new wood. Well, a lot of people have passed through here in the intervening almost 60 years. And it's time for an upgrade, a time for a refresh. And although we like things to be constant, they don't always remain constant. So we're going to be relocating. It isn't really terrible. We're going to be live streaming when I see everybody next from the historic circuit courtroom and the historic side of the St. Joseph County Courthouse. I have a nice corner office with windows that actually open. I don't consider it to be my office. I'm just warming the space for the judge that succeeds me. But it has been a privilege to practice in here. Lots of memories were made in here. I spoke of some of them this morning. So by the time anyone else does come to visit, this courtroom is going to be demolished. And that makes me sad, but it will be refurbished. And then in this nearly same configuration, it will have new bench, new walls, new carpeting. It will be new and perhaps last another 60 years. So that is not like they're tearing it down. And but everything in here is certainly anachronistic. It's like from the 70s, and I guess so am I. So we'll say what I said this morning. The three men I admire most, they caught the last train for the coast. That would be the Father, Son, and the Holy Ghost. So we'll see you when we come back in a new setting, at least for the next 8 months. And I wish everybody the best. We'll be back on the 21st.